Yeah, well, it's kind leaves to mention, well, the revisional application, well, the difficulties, well, the annexure, the impugned order, well, has been marked as page mark. And thereafter, well, struck off. That is why the department is not accepting the application. Usually, well, here is, it is not accepting it. It is only, it was marked and then was struck off. That is the all.
My lord, may I be permitted to mention, my lord, regarding item number 536 in the monthly list dated 5th June, my lord. My lord, next date is before the learned court is 21st, my lord. I have filed more than 2 months before, my lord. My lord, kindly, my lord. My lord, otherwise miscarriage of justice will be encouraged. No, my lord. Already they have time to time extend the interim order. That is against the interim order I have preferred, because my lord, in the suit has been passed in title suit, my lord. No, my lord. No, because of why I am filing the revisional application, my lord. If the title suit has been dismissed for default, but without hearing the order application for order 9, rule 9, order the application for order 39, rule 1, 2 has been disposed of. Without restoring the my lord original suit, title suit. No, my lord, there is no
Lordship,
Grateful, my lord.
may I be permitted to mention one matter for inclusion in the list under the heading extension of interim order, Lordship. Lordship, the interim order expiring on 16th of June, Lordship.
Milord, may I be permitted to mention, Milord, item number 8, Milord. I am for the Milord, may I be permitted?
Okay, apologize.
Milord, may I be permitted to mention? Milord, may I be permitted to mention, Milord, that is item number 8, Milord. I am praying for short adjournment, Milord.
Your Lordship, may I be permitted to mention item number 146 of the monthly combined list, Your Lordship. Your Lordship, I am for the opposite party, Your Lordship. The urgency is this, Your Lordship. The civil revision already become infructuous, Your Lordship. And the petitioner is taking adjournments, Your Lordship, by showing the pendency of the... Your Lordship. Your Lordship, I will do it, Your Lordship, in the course of the day, Your Lordship. Your Lordship, may it be taken, Your Lordship.
May I have my lord's kind leave to mention this matter, my lord? This is Civil Revision 1854 of 2023. My lord, the simple facts is I am the plaintiff petitioner, my lord. My lord, the urgency is that the defendants are constructing over the property over which I have got an order of injunction. My lord, they are still constructing a property. My lord, the next date is fixed on 2nd of July. No, my lord. Item number 1854 of 2023. It is running in the list, my lord. My lord, I am not aware of the same. My lord, there's another matter which is not in the list, my lord. I'm praying for inclusion in the list.
Grateful. Have your Lordships kindly, my lord, I am praying for leave, my lord, to file without certified copy. But what has happened is, my lord, we are assailing, my lord, an order passed by an arbitrator. Now, my lord, the orders that are being provided to us, those are being provided by way of email. Now, my lord, the department is saying you have to provide a certified copy. Now, my lord, in this case, there is no certified copy. I have taken out a specific paragraph in that again. I'm grateful to your Lordship.
Lordship, may I be permitted to mention this matter? This matter, I was enjoying the interim in extension, and it expired in February. And since then, the item has not come under the list. Not sure.
The Lordships can leave. I'm mentioning a matter for extension of interim order. Five civil revisions. 17th it is expiring. Yes, Your Lordship. There was a direction for filing pleadings. It has not been completed. Lordship has to extend the time and extend the interim order. Lordship, only for extension of the interim order, it is going on for a year now. The pleadings, 5 analogous applications was being opposed to heard together. Your Lordship will kindly keep it tomorrow as for only for the purpose of extension. Lordship, I was instructed today, Your Lordship. It was supposed to appear in Your Lordship's list. That was on 8th of June. There is an order to that extent. Your Lordship will kindly consider.
Followed by the four, because I'm just wasting time on mentioning everything. No use to purpose this stuff. I think I will do that system and we can go on mentioning. Give it.
Lordship, if it is, I will do that, Your Lordship. Much obliged. No, I will give notice. Much obliged.
My lord, this is my application, man. My lord, second paragraph, my lord, it reveals.
Paragraph of.
My lord, of the order, my lord.
The second line of the second paragraph of the order dated 12/2023. Execution completed B. Completed and going on.
My lord, one more leave, my lord. My lord has directed me to serve upon all the parties, my lord. Since, except for opposite party number 1, are all the pro forma opposite parties my co-plaintiff. If the serving on the right, much obliged, my lord.
The extension of interim order, and I have served this copy. Evidently, service is there. As per the lordship's direction, I have served this copy. Now, the interim order was till 2nd week of March. The matter was running in the list from first week of March. No, I tell lordship, under the extension of interim order, the matter was running in the list from first week of March. The matter was not reached. My Lord Justice Vivasundar Pattarayam, this matter was running from first week of March under the heading extension of interim order. The matter was not reached. The order impugned, I tell lordship. Kindly see this impugned order. Under section 151 application, because there was an order of status quo with regard to not to change the nature and character of suit property. Now, my lord, the plot number 3349, there was not existing of drain. The drain is from the local resources from other plot. Can you see this order impugned? Yes. 151, they have made an application for police protection. Because they are specifically there that these due to drainage system, that order for laying out has been stopped. But there was no drainage either in the plain or in the injunction application. There was no drainage that has not been pleaded. And in the local inspection report, kindly see the local inspection report, clear. On the suit plot, there was no drainage. I'll see this plant. I should see this plant. The suit plot 379 is the Jola, Joljomi. And local inspection report clearly reflects as per 31, 33 that there was no. Yes, kindly see this order impute. It is clearly stated about the interrogative page 2, inner page 2. On perusal of the instant application, you also got it. The impute order inner page 2. Now kindly see the observation on the perusal of the instant application under section 150 of the Code of Civil Procedure, written of the other matters on record. The GD lodged by the plaintiff before the concerned OC Kejui such and such. The concerned case stand over. It clearly appears me. The attempt had been made of the concerned defendant to change the nature and character of property, and if the said defendants are allowed to continue this said overt act, it would cause serious prejudice to the interest of the plaintiff. And now the kindly see local inspection only one thing, but kindly see, but I will satisfied to lordship.
Passed by a board, the board has every right and duty to ensure that that order is complied.
Undoubtedly, but kindly see the local inspection. But only one thing, but I will maintain the status quo, but the court says what the order was passed. I am disturbing not to damage the water. Then yes, clarify. But this only one thing only.
September 22, by the of the order of instruction, which police has been allowed. It appears to the court that order has been passed in time from number 16 of the for the longest court on January 20.
June.
Order was also extended from time to time. The plaintiff alleged that in violation of the order of status quo, the defendant tried to disrupt the passage of drainage. From the drainage of groundwater from that
Can you look at inspection report? Page 31. But drainage in plot number 3737, not 3739.
allow me. And the finding of the board, but the finding that there was a disruption by the order of the fact that there was an attempt in front of the order. However, the finding of existence of a drain and corruption of a drain shall be only restricted for the purpose of disposal of that drain or we and the part of the state and however, this was the when an order of injunction and or defense both are parties are bound to comply with state order to the matter of party policy. What is passed by courts, adhered to by the parties, and the court had to try to ensure that this policy it requires under such the clarity of operation by the order. Okay.
Only one thing, no. On the report inspection, we reflect that the drain is plot number 3737. But that is inspection report is clear.
You have said you recorded it.
No, what the inspection report clearly reflects that the drain is plot number 3737.
This is also Milord same problem matter was running in the extension heading for the all where they were appearing for the last two occasions. It was being extended. Milord, what happened, Milord? A decree, Milord, an award, arbitration award has been passed against us ex parte at the point of time when my client's directors were all in Milord police custody in jail. Now, Milord, nobody was there to receive Milord summons. Milord, it had passed ex parte. Milord, execution, Milord, proceeded. Now, Milord, we filed an application under order under section 34 for setting aside the arbitral award. Now, Milord, in the meantime, the award holders, they have filed an application under order 21 rule 54 for attachment of the property in the execution case. Now, Milord, Milord, kindly see the initial order. Justice Dasgupta has said that since the section 34 is on the verge of completion, do not proceed with the attachment order till that date. Milord, in the meantime, what has happened? Our Milord argument in section 34 is complete. It's fixed for their argument in the section 34. No, Milord, what happened, Milord? Now this only, Milord, sometimes in July, Milord, it's fixed for their argument, and thereafter judgment will be delivered. That is true. That is true, Milord. No, Milord, now, Milord, they also did not challenge it, Milord. It's Milord, stay. We did not pray for any stay because, Milord, because so, Milord, true, Milord. Milord, that now, Milord, the proceedings are, Milord, the argument is complete. They are to only on one day, Milord, that's fixed in July. They will be argue, Milord, and that will. Till that time, Milord, that was the, Milord, observation of the Milord order impugned is 29/2022. Order number 10, Milord. Kindly see, Milord, it was fixed on 7/11/2022 and Milord, yes, Milord.
Milord. No, Milord, it's July, Milord 2023, sometimes in July. Milord, it's in the same court, Milord, July. July is Milord. Oh, the July is Milord 34 hearing. Milord, that to take instructions. Kindly direct Milord 34 Milord to be concluded Milord in the next day.
September 20. Passed by the learning.
Maintainability of the execution case.
The award letter appeared that and the same has been award for the party order award and an appeal therefrom under section 34.
Commercial court at Rajarhat. Shubhashish the আসেনি accident হয়েছে দাদার সাইডে না শুভাশিস ওর টাইটেলটা কি
That the property
শুভাশিস এই যে বর্তমান মিউনিসিপ্যালিটির অ্যাডভোকেট
by the application
হাওড়া স্টেশনে পড়ে গিয়ে দুটো হাতই ভেঙে গেছে 3-4 দিন আগে
was not in the name of the award letter. The execution not proceed by way of an attachment of the was not by the motion. The property sought to be paid for attach the property not shoulder paid for attachment. So was put in the name of the award letter.
বাঁচিয়ে দেওয়া গেছে ভালোই চলছিল না তুললেই
That what they all the directions from the company for summer.
and
An amount of award of rupees
2 crores and also
5,000.50 along with percent. That amount
2 crores and order.
I think the award holder. For attachment readily available award holder under the form. One could also observe that the company that was a domestic person and the award was binding against the not relevant. All the letters had been summoned or wrong. Thus, that Right. Proceed to take the case. The applicant domain state. But by the award. By the award. Although the award holder officials have the award should come. Not admitted. Or not admitted. They are the award. 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 Plus the yeah.
And that no, no. We are more concentrating now on the section 34 million.
Not even. By the as it is
Kindly do not observe that. Kindly do not observe that. Kindly fixes the time limit from here only. 1 month, it's argument, our argument is over.
My lord, Mr. Subhasis Bandyopadhyay is appearing in this matter on behalf of the
Met an
Bardhaman
accident.
municipality.
Mr. Subhasis met an accident.
Accident was happened with him. Both arms has been broken. So my lord, kindly
Not coming.
plaster has been removed, my lord, but he was under crepe bandage, my lord. So he is not able to come to the
No, I'm for the petitioner.
on behalf of the Bardhaman municipality, my lord.
1 month it was running, expired. We are the everyone kindly will not. It was running month, March, April. It was running. Now, what happened, my lord? My lord, no, my lord, it depends upon the matters, my lord. What can be done. What happened, my lord? There was a writ petition filed before this honorable court where your lordship directed, my lord, to consider the representation against unauthorized construction. My lord clients, my lord, are my lord shop owners. They are my lord temporary shop holders in the market. Now, my lord, naturally, my lord, order of demolition has been passed. We have filed an appeal under 218 before the competent court. That is pending. In the my lord, we have filed also an application for stay. Court is continuously postponing the hearing of the stay application. No, my lord, kindly grant us stay. Otherwise, they will implement. My appeal will become redundant, infructuous. That is the. Willard court, yes, 218 appeal. Court is only prayed for stay. Court is only postponing, Millard, the stay application. There is no order passed in the stay application. The complainant was never a party in the Millard appeal. It's only the Bardhaman municipality. They are challenging their order only. Okay. And kindly see page 25. Already, Millard, in spite of Millard pendency of the appeal, this notice was issued. Complainant. No. Court is only postponing now. There were now resolution, Milord, due to heat, Milord, these are going on. And fourth, Milord, every court.
Yes, take down.
Every
Purpose of the revision is. Wow. The learned court below. Along with the application of the order on the next. At least on the point of interim. Being agreed by an order of demolition. In this case, number 76 of
2022.
For state of the order. That unless a short election is, unless the petitioner can get, I think, got out, some sections are in charge of law. The petitioner submits that unless
এই সবুজ পাতা এখন কি করে এলো? পুরোনো মামলা। ষোলো তারিখ বলেছিল না? বলেছিল 16 July বলেছিল। Yes, yes, this annexed here. Kindly comes to page 23. Page 23.
One country control. Five application for extra party in the proceeding. And the same application. Does not whether stay filed by was at all taken up or considered at least on the point of law. Next, the revision of the direction of all the learning sequence. Important order one. Here are two. Here. At least from the point of a short.
Interim order.
Along with the on the same day, when the application under order one shall be heard. The proposal of the matter is heard on the next day or not.
Page 25.
In respect of the construction.
এই তোমরা অবজেকশন দিয়েছো স্টের?
যাই না আমি
লিবার্টি নিয়ে নাও।
Filed by the parties.
যেদিন থেকে অবজেক্ট না খুল, যেদিন থেকে না আমার তো রইল। They are not party to the lease before the trial court even. Let them hard, let them can. In the writ petition, order was passed by your lordship only.
Yeah, prior to the
prior to enlistment of this matter, my lord, on 1st of May 2023, to avoid all the, my lord, complication, my lord, I have again served, my lord, the copy of the revisional application, both up, my lord, the opposite party as well as their learned advocate. My lord, postal tracking report said it's delivered, and my lord, the learned advocate has received, my lord, by hand. Defendant number, my lord, 1, 2, 4, 7 series, 8 and 9 is the petition of the petitioner before your lordship. Not suit for declaration. If your lordship once looks up, my lord, the order impugned is rejecting my application for local inspection. Now, my lord, prior to that, my lord, one application of mine was also rejected. The court held its res judicata. My lord, why, my lord, my first application was rejected? The ground was that initially plaintiff prayed for a local inspection. The local inspection was being held, report was filed, objection was being made, but report at that point of time was not being accepted. At that juncture, I filed an application for local inspection. That my initial local inspection petition was being turned down, saying that no, since one report is already on record, which is about to be accepted or rejected, whatever, that decision has not yet been arrived. So your second application is not maintainable at that juncture. But subsequently, when my second application is being filed, at that point of time, the learned advocate who was appointed as a inspection commissioner, he died, unfortunately. So that's why, that report cannot be on board at this point of time, because I filed my objection. The other defendant also filed the objection, but not, since the learned commissioner is no more there, we cannot cross-examine him. So at that juncture, the second application of mine was being filed. The court said it's res judicata. In my respectful submission, it's not, because the entire order that was passed in my first application was on the basis of the first report, which was already on board. But after the death of the commissioner, my second application will not be turned down on the ground of res judicata. This is my first submission. Secondly, what is the crux of the dispute? I can show before your lordship. The crux is, the kindly once looks at the prayer in the plaint at page 21. I do have my separate counterclaim in this suit. But what prayer the plaintiff has claimed? নালিশি কতপশীল এজমাল পুকুর থাকা এবং তাহাতে মূল বিবাদীগণ কোন প্রকার বাঁধ স্ট্রোক পার নির্মাণ করিয়া খণ্ডাংশে বিভক্ত করিয়া পুকুরটির অখণ্ডতা বিনষ্ট করিতে না পারেন, তাহার জন্য মূল বিবাদীগণের বিরুদ্ধে ডিক্লারেশন এবং পার্মানেন্ট ইনজাংশনের কনসিকুয়েন্সিয়াল রিলিফের ডিগ্রি. So they stated, so I may be restrained so that no par can be construction dividing the pukur. This is the prayer. In my written statement and counterclaim, I stated very specifically there is already an existing of par, and I prayed for consequential relief for partition. There, the plaintiff's first inspection that has been prayed for, I have annexed that application. Kindly see page 34 what they have prayed for. Very interestingly, they have not prayed in the schedule of the application that whether there was existence of the par is already there or not. Kindly see 4 points. So I have also annexed the report, the learned advocate commissioner. No, that's why kindly looks at the report, the learned advocate commissioner who unfortunately died. Yes. Yes. Kindly looks at the report, page 36. The observation is at page 37. The learned advocate commissioner who unfortunately died. Nothing is being mentioned. So the crux. No, that has been prayed for, but since the learned advocate commissioner died, now no decision on that point. And specifically my application, I have prayed at page 50, kindly see. The court has to come to a conclusion on this. An officer of the court has to go there and report whether that is already there or not. Thereafter, the question of giving. And the observation portion, the learned advocate commissioner has. Yes. Yes. But nothing is. That is my objection also against the commissioner's report. But I couldn't able to cross-examine him. And the my last application, page 50, my lord, kindly once compare this, what I have prayed for, because this point has not been, my lord, answered. My specific point is to inspect the cost shoot land and to note and report whether the cost shoot land has been divided into two halves, eastern and western side, by raising an embankment or bath. Specifically, this application was filed by the plaintiff. No. My second application, which was turned down, saying that one report is already on board, that is about to be accepted, for which you have already filed objection. So second inspection was not necessary at that point of time. I'm carrying that order with me. So that was precisely on the ground that since the first inspection report is already there, that is not yet been accepted. But my second application of local inspection, but in this time, Lord, may I serve only a notice, because on 1st of May itself I have served. Yes. Fine. Great. Time for the opposite party number 1.
No time for the petition. But here, Lord, the dispute between the two defendants, not between the plaintiff and defendant. Lord, the defendant number 2 claimed himself to be the constituent attorney of the defendant number 1. And the written statement was filed by the defendant number 2 on behalf of the defendant number 1 also, on the basis of non-est power of attorney. Lord, at this stage of the evidence, I filed an application, impugned application before the trial court for direction upon the defendant number 2 for production of that documents, the power of attorney, on the basis of which he filed the written statement on my behalf. Lord, by the impugned order, that was rejected. So far as the plaintiff is concerned, Lord, the plaintiff has no option.
No. Opposite party number 1 is, my lord. Yes, opposite party number 1 is the other defendant. I'm representing the defendant number 2.
So far as the plaintiff is concerned, plaintiff has no objection. Plaintiff didn't join that issue. Only the fighting between the defendant number 1 and defendant number 2. And Lord, that is my innocuous prayer before the learned trial court that was rejected by the impugned order.
But it's not so simple. We are the two siblings, two brothers. Now, prior to this production, Order 11, Rule 14 being filed, he has tried to file application under Order 8, Rule 9, saying, allow me to file a separate pleading. In that application, he specifically admitted that, yes, both of us have filed the joint written statement, but subsequently my brother didn't contact with me, didn't give us any report. I have perused our joint written statement and I found that some important points have been left out. That application where they have accepted that this is a joint written statement, that thereafter his prayer for Order 8, Rule 9 turned down. He again tried to file an application stating that allow me to adduce separate evidence. Since the defendant number 2 has adduced evidence, I may be also allowed since I was there. There also he admitted that yes, joint written statement was being filed. No, both the application was turned down, no challenge to that. Because after the closure of the evidence of defendants, he applied for that. Now this is a discretion. The court said, no, you have filed the joint written statement. He accepted that, yes, we filed the joint written statement. Thereafter, his prayer was also turned down. No challenge of both these two applications, which was the order was being passed. Now turning around this separate, today, this stand which has been taken is contrary to the stand there in that two application I am carrying. He has accepted that, yes, joint written statement is being filed by us. But thereafter, there are difference of opinion between two brothers. The brother did not inform me about the progress of the suit. No. Yes, become bad. The relation become bad. Yes. No,
Yes, yes, Lord, that is the Lord.
then he has to pay for the transposition or the other thing. How can he say? Because it's a suit for partition. He has accepted today the stand which has been taken by the impugned application is that I don't have any authority to represent him. Whereas in the previous application, he has accepted that yes, both of us filed joint written statement. I am carrying with that pleadings. Kindly see, my lord, the pleadings. It's marked portion, but still, kindly once looks at, it's an order 8 rule 9 application. See the language. And this is recalling application. That blood he has not challenged. That order was being passed and not challenged. That is not the learned trial judge. This is not the recalling. That is but here the production has been asked for by taking a complete separate stand that no power of attorney, no consent was being executed to file the joint written statement. So this is a third attempt. And the court rightly, after this is now the cross-examination, cross-examination.
Or argument.
Yes, argument. Cross-examination also.
At this stage of argument.
And order 11 rule 14 is very clear. That you know.
Additional advocates. So give me that.
Yes, whatever.
And blood, the trial court be directed to consider the argument which shall be submitted by my learned friend who will be newly engaged, blood, at the time of blood passing the judgment also, blood.
On the basis of the material already restrict.
Materials on record. Materials on record. Great, blood, this is my service.
Maybe that.
I have also have to respond my. Probably that is.
That. It's a very history, right?
I am order dated. January 5, 2023, passed by the learned. For an Howrah, he types from 2006. By the order impugned, 1-4, rejected an application dated September 15, 2022, filed by the defendant number 1 in the suit under order 11, 12, 14, from the court. By the application from defendant number 1 of the petitioner, pay for a direction about the number 2 to produce the power of attorney before the learned court for inspection by the petitioner as the petitioner denies the existence of any such power of enabling the authorizing the opposite party number 1, that is the defendant number 2, contest the suit and file the suit statement on behalf of both the defendants. Such application was turned down by the learned court below on the ground that
Both these two application was being turned down and that was not being challenged by him. And also order 11 rule 14 only applies after closure. That's why. No, at that point of time, after closure of the yes.
the ground that the defendant number one were contesting together and had a common cause of action, could not take advantage of the content of the provisions. Order 11 moves 12, 14 and 18. The law is also recorded that by two earlier orders dated April 12, 2020 and August 4, 2020, two applications filed by the petitioner for filing a separate and for reducing separate evidence at the DW had been rejected. The petitioner had not challenged the same orders for a petition court. Moreover, before a higher court. Moreover, at the stage of argument, useful purpose to preserve. Ask the defendant number one to use the power of attorney. Then it was an agreed position in the application filed by the petitioner saying for leave to file a separate statement that he had filed the under the circumstances on the basis of the findings of the report, the report pass any conflicts. It appears to the court that after the complex and evidence was recorded, some mistakes have crossed up with the and hence the petitioner wanted to contest the court. As it was challenged, the person challenged orders already passed by the court earlier, keeping the application of filed by the petitioner, one for filing a separate notice and the other for adducing separate evidence. So the use of purpose to preserve technically number two, to use the power of attorney was that the defense contested and had filed the document. However, as seeks to case further for to take his own case before the learned court, he is granted to the petitioner to appoint any learned advocate advance arguments on behalf of the state defendant number one in the suit. Advance arguments on behalf of the defendant one in the suit. However, such arguments shall be restricted to the contents of and the as matters which are already on record. Those already on mutual by the above.
Extremely different.
Great. May I take back those application or it will be? Great.
I am for the petitioner.
Lordship, I am for the opposite parties 3 and 4.
Initially, interim order passed on March 2023. Thereafter, another extension was made, and this week interim order will expire. Here the petitioner has challenged an order passed in misappeal, the statutory appeal under section 218(3). That order is challenged before your lordship. If your lordship kindly come to page impugned order, last but 2 page, municipal appeal number 1 of 2018. During the course of hearing, your lordship got it. During the course of hearing, learned counsel for the appellant submitted that the
Respondent number 1 and 2 passed a demolition order without compliance of provision of law. Thus, the impugned order is bad in the eye of law. This was not my case, my lord. I have never challenged the procedural latches on the part of the municipal authority. If your lordship kindly come to page 47, this is the order of the municipal authority.
Lordship, I pray that your Lordship kindly notes down the submission that they have not challenged any municipal procedural latches. I'm going to come back.
Well, if your lordship kindly come to page 47 once, the order of the municipality. Well, page 47. May I read, my lord? My lord, initially the order of demolition was passed, which is page 43. If your lordship kindly come to page 43. My lord, পৌর বাস্তুকারের রিপোর্টে দেখা যায় শ্রী নাহারবাড়ির উত্তর দিকে একটা কমন প্যাসেজ বর্তমান। তিনি তাহার বাউন্ডারি ওয়ালের কিছু অংশ ভেঙে কমন প্যাসেজটি ব্যবহার করেছেন। My lord, that means boundary wall was existing. এই ব্যবহার বন্ধ করার জন্য শ্রী রায় নতুন করে রাস্তাটি ওয়াল দিয়ে বন্ধ করে দেন। এই কমন প্যাসেজটি কিছুদিন পূর্বে পৌরসভা থেকে কনস্ট্রাক্ট করা হয়। সব কাগজপত্র দেখে এবং সবার বক্তব্য শুনে সিদ্ধান্ত নেওয়া হলো শ্রী রায় কর্তৃক নির্মিত ওয়ালটি আগামী 15 দিনের মধ্যে ভেঙে ফেলতে হবে। That order was challenged before the writ court. Page 44. My lord, if your lordship kindly come to the last paragraph of page 44, the observation of the honorable court. The impugned order passed by the chairman West Bengal Municipal Act 1993 permits construction of boundary wall up to specifies limit without obtaining prior permission from the municipality. The finding of the impugned order is not that the boundary wall is beyond the permissible limit. The Act of 1993 also allows proceeding under section 218 to be undertaken for the purpose of demolition of unauthorized construction. Now the demolition order passed for construction of a boundary wall, which is permissible under the permissible limit. On that issue, the Board of Councillors, my lord, page 47, kindly come to paragraph 2. The members had the therefore, my lord, for the construction of boundary wall under permissible limit, there is no approval is needed. My lord, kindly see paragraph 2. Yes, this is the point.
Lordship, there is no.
They have said, no, my lord. No, in the misappeal, there is no whisper. In the objection filed by the municipality, there is no whisper. Nothing has been recorded in respect of my building. Everything is on the boundary wall. They have stated unauthorized construction of the building. With regard to the building, there is no, my lord, nothing.
No, your Lordship, I'm for the opposite party number 3 and 4. I'm the private respondents here. I'm going to just state my facts in brief. Your Lordship, this is a 12 feet common passage. Lordship, no. This is a boundary. Lordship, the building has been written down in the order. Lordship, kindly hear me out on this. They have not challenged any procedural latches in the order. Not sure. Lordship, this is. Lordship, kindly come to the impugned order. The impugned order, the appeal. First miscellaneous appeal. Internal page number 9. I'm going to read out the middle paragraph. Per contra, learned counsel for the respondent number 1 and 2 contradicted the submission and submitted that municipality acted in accordance with law after giving an opportunity to both sides of being heard with regard. Kindly this part. So impugned order was passed in accordance with law, and dispute of 12 feet common passage is a dispute of civil nature. Hence, this order explicitly says this is not a building, but a common passage. And this order has been challenged. Exactly, and that order has been modified to that extent. And in the ordering portion, I'm going to read out another portion in page number 10. From the middle portion, it appears from the impugned order dated 29/9/2018 that appellant has been provided with an opportunity of same thing. All inspection reports has been taken into consideration while passing the order by respondent number 1 and 2, and agenda 4 of the minute book categorically stated. Therefore, this court does not find any irregularity or and arbitrary action on the part of the respondent number 1 and 2 in passing the order under the above circumstances. This court is of the view that such order does not seek any interference. However, this court is surprised. Lordship. Lordship, this order is not for a demotion. That is a mere. Lordship.
Second paragraph.
Lordship, the building has to be demolished. I understand it is written in this order, but the appellate order says that no, the appellate authority specifically finds that this is a boundary wall, and thereafter clarifies it. Lordship, I understand, but the problem would be Lordship, if Lordship may kindly pass an order to the extent of only the boundary wall. It is written, your Lordship. Reason of demolition of the unauthorized boundary wall. Lordship, I understand it is.
My lord, for that reason, in the first paragraph, in the my lord, order of the Honorable High Court said that there is no requirement of approval for construction of boundary wall under permissible limit. But in first paragraph, last 3 words, without any approved plan. That means he goes to the building, not upon the boundary wall, but by taking this order, they are trying to demolish the boundary wall. My lord, kindly see the first paragraph.
Internal page
last
number
line.
10 of the impugned order once. Kindly see, it has been specifically mentioned that categorically stated the reason of demolition of the unauthorized boundary wall. Me as a private respondent, my problem here is that it is a common passage, and I have been using that since the past 25 to 30 years. Now suddenly they have constructed the boundary wall, and my problem is for my ingress and egress. Lordship. And
That has
the
been
civil
filed.
suit has been filed already. Lordship, I bow down.
The building is without plan. There is that, and you are saying that it is not an issue.
It is not.
How can you not say that going beyond the boundary wall also that?
Lordship, I had made a complaint on the basis of that boundary wall. Lordship in my lord, kindly hear me out. Lordship, I understand. Kindly, this is Lordship.
The municipality and I will speak the guidelines as what they will decide and. Decided on.
My lord,
The municipality finds there is a bill without a plan. The Supreme Court finds there is a boundary wall without a plan. What will?
Lordship, I understand, but my complaint to the municipality was to the extent of and that order has been clarified in the appeal order.
That is why. Suppose I get the merits of the plan, what happens to the order of the plan?
Lordship,
What is not in the order?
Lordship, but the municipality today, as of now, is not here. Kindly, I ask that your Lordship kindly hears them once.
my lord, matter is due to appear today, my lord, fixed today.
For extension of interim
Yes,
order.
yes, they have filed opposition, my lord. My lord, another thing, my lord. My lord, the boundary wall is on the common passage. My lord, there is dispute. Municipality cannot decide.
Lordship, they have filed. They have filed a
I have filed that suit.
Whether there is a boundary wall constructed by you on along the common passage. Two, what is the height of the boundary wall? Three, whether the height exceeds the height which is required by law for permission. Four, if no permission is taken and the height exceeds the allowable limit, then.
My lord, other than the height, my municipality cannot decide the issue, my lord. Yes, my lord. If height is exceeded, otherwise they cannot.
Lordship, if
Decided
the
by
height,
the civil
if
court.
the height is similar, but it is encroaching my passage and
Should be suit.
in this
My lord, suit
in
is
the
filed, my
meantime,
lord, TS number two.
if the municipality finds that the height is not above that level and still my blocking of ingress and egress is there, I am going to suffer, your lordship. Lordship, I understand, but can an order regarding this, if your lordship may consider that, if your lordship may consider, this order has already been passed and only the ward building is there in the impugned order. Kindly hear me out. Lordship, however, from the Lordship, from the complaint and the appeal order, it is evident that it is a boundary. Can your lordship, may your lordship kindly, may your lordship appoint a receiver to that effect? That whether this boundary, it is the boundary wall or not.
For
To
that,
that effect.
civil suit is pending, my lord. Civil suit was filed on 2018. My lord, one thing I want to, my lord, place before your lordship kindly, if your lordship kindly take the opposition made by the municipality, page 3 once. My lord, they said the allegation contained in paragraph 3 relates primarily to dispute between the petitioner and appellant and the opposite party respondent number 3 and 4, and only a civil court is competent to adjudicate. They has admitted that.
Lordship, it will be seriously, I'll be in jeopardy if this order is being passed, because Lordship, I do, but my ingress and egress will be stopped. Lordship, I understand, but kindly consider that your lordship does not pass any direction regarding that. This is a purview under the civil code, and they cannot. Lordship, I understand, but kindly remand it back then to the municipal authority to decide this. Not.
Yes.
Lordship, I bow down.
Application has required challenge order asked by the Spicer Reserve. Earlier, sir, obey five factors asked by the number one referred by the petitioner. How many petitioners?
One.
Petitioner. Challenge order.
29 September 2018.
Order of the motion are against the I, the chairman of the municipality.
North
Dum
Dum.
Dum.
Not from the municipality. And the was asked. Remove the allow the common tax. This order was challenged for the court. Of this court. I find we have a voice. By an order dated by an order court. Current judgment that
Last paragraph of page 44.
chairman. Chairman.
Page 47.
Without jurisdiction. And the provisions of the must be undertaken for such order. The consequences of already and permission for construction. Permission for construction was up to the allowed. However, as there was a question of order. And I will order in view. Not chairman of the council. How many? All the. The petitioner. And others. That the construction of the petitioner.
It is not municipal road.
Lordship, it is.
This is my suit.
And
Your
that
lordship,
cannot be decided
yes,
under this
your
purview
lordship
of
will
this.
find page 42. No, my lord, there is a question, my lord. Your lordship rightly, my lord, gone to the, my lord, kindly come to page 42 once. It will be clear.
Lordship, these findings
plan.
are
But this plot is belong to a core family.
Lordship, these needs evidence.
They have, my lord, they have partitioned this plot. No.
Lordship, no.
What number 30? But without any plan. So there's nothing. Order was challenged. The learning that we found. Error. Order. Order. Pass. Select on the unauthorized was constructed. Are they not helpful? That. That ordered back law. It suffered from faculty and was beyond the scope of objection made by the court.
Second point is the road is a private common passage matter. This is not a
Lordship,
municipal
cannot
road.
in my humble submission that cannot be recorded.
And next, we also follow the not having right, not having decision side, whether the boundary wall had encroached upon the private property. The adequacy of opposition, what has the municipality said?
My lord, page 3, paragraph. My lord, Sudarshan Rai, Sandeep. Yes.
Small then, where are they?
Page 3, paragraph 8. We are using. We seven persons has purchased the land from Cord family. We are using. They are the outsiders. For this reason, I want to show this plan. If your lordship kindly see the plan once, your lordship, it will be clear.
I have
That
to
1, 2,
interfere
3, 4,
once.
5, 6.
I
These
have-
persons are using that road.
I must interrupt
But-
my learned friend once here. Lordship, please, if your lordship may come to my opposition. Just the prayer portion in page number 14, my opposition, your lordship. In the page number 14, the plaintiff is there, and the relevant portion, page 16, the prayer portion. A decree declaring the 12-feet common passage situated at the southern part of your plaintiff Schedule A property for proper and beneficial use and enjoyment of plaintiff. A decree declaring the defendant had no right of passage or interest over the 12-feet common passage is situated. They want that I do not enjoy that. That is the reason
What
they
is
have
their
filed this
right, my
suit.
lord, to enjoy the common passage?
And
They
in
don't
the
have any
garb of
right.
an appeal, they file this 227 and is asking that the boundary wall may stay. This is solely under the purview of the civil court, lordship. Lordship, the municipality cannot. If an unauthorized construction is there, lordship, and lordship, I understand that there is a factual error in the order. That is very much true.
Impossible. From that building to this building, it's impossible. It's really impossible. And my lord, no measures are being taken by no one. We are at the receiving end. Kindly, my lord, if some steps can be taken that all civil courts are in one floor or something of that sort. Only in the centenary building, not in the sesqui, 2 or 3. The 13. But practically impossible with 3 lifts virtually functioning. Your lordship may send your lord anyone. 4 lifts are there, 3 lifts are there, 2 function, 1 does not function.
And it's very slow.
And there are no courts in the 3rd floor or the 4th floor. 5th floor, Justice Raja Basu Chaudhary is not sitting. The lifts invariably, because there are so many staff working, they also are entitled to the lift. It goes up and down and impossible.
Office though.
It is impossible. I'm not blaming anyone.
Call for a meeting. ask
Okay,
them.
meeting. We are really at the receiving end. I'm very sorry to say. Only the Bar Association can take steps. Who is going to take steps? No one thinks about us.
You are a part of the bar association.
We are a minuscule part. Let me not go into it.
কি বললাম? Had encroached onto the common passage or not, and whether the complainant had any right of user in respect of the said passage. Next. It also his learned advocate also submits that a civil suit is pending with regard to the user of the common passage, and such user should be restricted to the persons who had purchased the properties from the Core family, and the passage had been delineated for the personal use of those persons alone. For use of those persons alone. Next paragraph. Learned advocate for the opposite party. Who is for the municipality?
Mr. Ghosh was appearing.
Sakani?
We called, but he has not come.
The other persons?
Show.
He has three
Yes, yes,
three
yes.
juniors. Call somebody. Debayan Ghosh, Shandip Ghosh.
We called Sudarshan Rai.
Call Shandip Ghosh,
সন্দীপ
Debayan
ঘোষকে
Ghosh.
ডাকো বিবেক আছে না সন্দীপ দার ফোন নাম্বার আছে না সন্দীপ ঘোষ বার লাইব্রেরি ওই ইয়েতে বসে
What did he say?
He is saying this is municipal. This is municipal.
Who said?
Phone call. He has not come to.
Who said it is municipal road?
No, no. Municipality is
Where in the opposition they have not said that.
They have only said, my lord, kindly come to page paragraph 10 of their opposition.
I've seen that.
That's all. Nothing more.
কি বললাম?
আমার
Submits that the learned civil court has clarified that the dispute was over a boundary wall, and even if the order of demolition mentions a unapproved building on the alleged lane, the said order of demolition has been rectified by the learned civil court, and no further interference of this court is necessary. Learned advocate further submits that the common passage was in the nature of a bylane maintained by the municipality and was not used as a common passage by only the purchasers of the property who purchased the same from the Kaur family. Learned advocate submits that the mistakes in the order of demolition have been rectified by the further order passed in the MISAPI. Hence, this revisional application should be dismissed. Next. Yes, you are for the municipality.
Sir, Sudarshan Rai is the advocate record. I was not instructed also. I wasn't prepared. I just came running by. I think someone.
I am directing you to do the whole exercise once more. Because you have said there is a building without a plan. And the whole issue was with regard to a wall. The court said nothing is wrong with your order, break down the wall. I do not find any parity in these two, so everything has to be redone. Ki bolna? Learned advocate for the municipality submits that the dispute with regard to the passage is civil in nature. However, the municipal authorities have the right to proceed against any unauthorized construction. Next paragraph. Having heard the learned advocates for the respective parties, it is a fact that an objection was raised with regard to construction of a boundary wall without permission from the municipality. While the complainant submits
the
that
complaint is not there. The complaint is regarding breaking the boundary. For construction, on a, your lordship has, this is the, it's like a T. The passage and on the common road. Now, there was a boundary all throughout page 43 kindly see.
there was a dispute was raised. Admittedly, it is an admitted position that a objection was filed with regard to the construction of a boundary wall by the petitioner. Initially, the municipal authorities directed the demolition of the boundary wall. The said order was challenged before this court.
Yes. Justice Bosak sent.
This court order directed that the procedure in terms of section 218 of the Municipal Act 1993 should be adopted, and the chairman did not have any independent jurisdiction to pass the order of demolition. His lordship also observed that construction of a boundary wall up to a certain height would not require the permission from the municipality. Next paragraph.
Another thing, my lord,
No, actually-
boundary was all there.
Also.
Reconstructed. Broken boundary wall. No? The
They are minded only to park their cars. They conduct gadir ব্যবসা, and in that passage, I am a teacher. I am a teacher.
Cannot be
Next.
submitted here.
On the basis of the order passed by this court, a further proceeding was initiated and the demolition order was passed directing the petitioner and others to demolish a building, unauthorized construction of a building without any plan. For convenience, the order of demolition is quoted below. Such order was challenged by the petitioner on various grounds by filing miss appeal number
Miss appeal number 1.
municipal appeal number 01 of 2018. The learned civil court found that the authorities had proceeded in accordance with law and passed the order in compliance with the principles of natural justice. Hence, the order of demolition was upheld with a direction that the records revealed that there was existence of an unauthorized boundary wall. This finding, in my view, ought to have prevailed upon the judge to remand the matter back to the municipality for a proper adjudication because of the factual errors which are apparent on the order of demolition. The learned court also did not ascertain whether the boundary wall was permissible under the municipal law or whether the nature and height of the boundary wall was such that permission from the municipal authorities were required. Further, if it is a case of the parties opposing such reconstruction of the boundary wall, that the wall had encroached on a municipal road or a PWD road, the said objection ought to have been decided both by the municipal authorities as also by the learned civil court as a separate issue.
Yes.
Under such circumstances, a mere observation of the learned civil court with regard to the existence of a unauthorized boundary wall, which did not find any mention in the order of demolition, is perverse, and hence the order impugned is passed in municipal appeal number 01 of 2018, as also the order of demolition dated. Demolition date এখানটায় আছে, হ্যাঁ এখানে আমি এটা কোনটা
There is a direction
29 September
29 September 18.
days 29 September 2018 are set aside and cancelled. The municipal authorities will redo the entire exercise on the basis of the objections raised with regard to the alleged reconstructed boundary wall. While doing so, the following issues shall be decided: A, whether the boundary wall which has been reconstructed by the petitioner was within the allowable limit, or the height of the building wall was such that permission as per the building rules or the act was required from the municipality. B, whether the wall was on any municipal road or a PWD road. C, না এই দুটো থাকলেই হয়ে যাবে।
The second issue perhaps, with respect, is there is a suit pending.
No, that is a common passage, but if it is a municipal road, then they have a right to remove it.
The municipality, how will it, I put this
No,
question
on
to.
municipal road, they can, the law permits that, even panchayats can. If it is a exclusive, is a municipal road or a road maintained by the PWD, and such fact is reflected in the কি বলে ওটাকে in the Moja map.
There is no road in Moja map because it is the one plot only.
The single plot was
fine.
subdivided,
Is a
and I had purchased.
all right, is a municipal road or a public road?
Private public.
It's a private road. It's a private road.
Private road, not a public, or a public
7
road,
persons are
or a road which has been delineated in the purchase deeds
Yes.
of those persons who had purchased the entire area from the Kaur family,
Yes.
and the said passage had been kept aside in all their deeds,
Lordship,
accused of those persons or not.
Lordship, this question would influence the
Then what?
Lordship,
Why did
this would influence the suit. Lordship, I understand kindly.
If it is found that the road is a municipal road on the basis of the land records
Lordship.
and the Moja maps, etc., or the municipal maps, municipality also has its own map. In that event, steps can be taken by the municipality in accordance with law. If the height of the building is found beyond the allowable height of the wall is found to be beyond the allowable limit and to have been constructed without permission, steps shall be taken for demolition in accordance with law. The issues to be decided by the municipality here and on the basis of this order shall be restricted only for the purpose of the objection raised by the opposite party number 2, opposite
3 and 4.
3 and 4, and shall not influence the civil suit.
Grateful, Lordship.
The entire exercise shall be completed by the municipality within a period of 3 months from date of communication of this order. Prior to any decision, inspection will be held at the premises in question in the presence of the parties. Full stop. A report shall be prepared and handed over to the parties. Stop. The parties will be entitled to respond to such report by filing their written objections, rejoinders. Thereafter, a hearing shall be given to all and the matter shall be disposed of in accordance with.
I'm grateful, Your Lordship.
Yes. Yes, next.
Yes, my lord, I am for the caveats, my lord. My lord, I have to submit before lordship by tendering apology that my clerk has lost the brief. Therefore, my lord, I prayed before my learned counsel to give a copy.
One thing I have seen,
Yes, my lord.
a copy of a power of attorney was admitted in evidence
Yes, my lord.
without either there being a recording under section 63 that it was compared with the original and prepared and compared with the original, or first that if that was done, it could have been admitted. Secondly, if it
65C,
is
foundation
taken
is not
as
there.
secondary evidence, in that case, a certified copy should have been produced.
My lord, my humble submission, I am praying for adjournment only for 2 days, my lord, nothing else, my lord.
So I was going to give you the permission to file an application as to why the power of attorney cannot be filed by you and to file a certified copy, because under the Stamp Act, certified copy of a document is admissible in evidence if it is a registered document. So these are the two issues. So if you can, I can do that.
My lord, that cannot be perhaps done.
No, that can be.
No, kindly see, my lord, the evidence.
No, but nothing is annexed.
This is the certified copy, kindly see. Last XXX. Very good.
Yes.
Kindly see, this is the XXX 4X, my lord, where the officer is deposing. It is not a certified copy and
True. I will give them liberty to bring the certified copy
Yes, my lord.
and tender it in evidence. What is the problem?
no, my lord, it said that it does not even bear the seal and
True. That true copy will be expunged, but he will be granted liberty to bring a certified copy. That's all, which is an admissible piece of evidence under the Stamp Act. And certified copy can be allowed as a secondary evidence. You have to just write,
Yes,
file an
okay.
application saying why you cannot. So I'll dispose it off. Take it off. Mr. Bhattacharya,
kindly do not clarify the leave in that way, my lord. They shall be permitted to take steps in terms of section 65.
no.
Well, otherwise, my lord, everything, my lord, virtually, my lord, everything is open. But kindly, my lord,
why? Evidentiary value comes later.
no, my lord, kindly only, my lord, makes observation
Alright.
that they shall, my lord, file application in terms of section 65. Otherwise, my lord, virtually your lordship is allowing it from here. My lord. Kindly do not do
That
that.
should be done.
Kindly do not, my lord.
না, ঠিক আছে। ওইটুকুনি you have to be kind. নাহলে আরো দিলে ওইটা নিয়েই চলবে, বুঝতে পারলি না? This is the whole the way the suit will go and your defendant. No?
আমরা তিনটি order suffer করছি তো।
শেষ হয়ে যাক। Yes. The revisional application has been filed challenging an order dated November 28, 2022, passed by the learned civil judge, junior division, second court, Baraipur, in title suit number 80 of 2011. The application filed by the defendant claiming that exhibit 6 be expunged from the record was rejected on the ground that credibility of a document would be adjudicated at the stage of final hearing and the defendant would not suffer any prejudice as the said document has been marked as an exhibit with objection. The volume was also produced by the upper division clerk of the office of the ADSR Alipur. Next paragraph. Mr. Bhattacharya submits that the document is a true copy. এখানে evidence একটা criminal minor একটা আছে তোর কাছে? আছে? Criminal manual. এটা কি জ্যোতিদার বই?
Library.
Yes, কি বললাম? Of a power of attorney which was neither endorsed to be a copy compared and compared with the original
Under the same mechanical process. That is
or by a mechanical process
because photocopy is not, my lord, same mechanical process.
ঠিক আছে? He further refers to the cross examination of the of the representative of the ADSR Alipur, who has categorically deposed in his cross examination that the document was neither a certified copy nor does it bear the seal and signature. Learned advocate for the opposite party opposes such submission of Mr. Bhattacharya and submits that the volume automatically proved the existence of the document, and hence the learned court below rightly rejected the application by marking the true copy of the power of attorney as an exhibit with objection. Having heard the learned advocates for the respective parties, this court is of the view that secondary evidence means and includes certified copies given under the provisions contained in the Act, Evidence Act, or the relevant statutes. Copies may be copies made from the original by a mechanical process, which in themselves ensure the accuracy of the copy, and copies compared with such copies. C. Copies made from and compared with the original. D. counterparts of documents as against the parties who did not execute them. 5. Oral accounts of the contents of a document given by some person who has himself seen it. এখানে 63 of the একটু দেখি এখানে আছে তুমি করে দাও তারপরে In this case, a true copy of the power of attorney was produced, but neither was it compared with the original.
Lordship is observing it's a true copy, then means it's true
Copy,
of the
copy.
copy because it's neither sealed. There is, we are doubtful whether it's a true copy at all.
Copy produced with which the upper divisional clerk said in his cross-examination
Neither stamped nor sealed.
to be
Neither sealed nor stamped. পাঠিয়ে দেবো, জেরক্স করে পাঠিয়ে দেবো।
not a certified copy, and it did not bear the seal and signature of the authority. In the cross-examination, the said representative further submitted that he was not aware whether the deed was issued from the said office or not. Under such circumstances, this court is of the view that the provisions of section 63 of the Evidence Act has not been followed by the learned court below while admitting Exhibit 6 and marking the same with objection. Under such circumstances, the plaintiff is granted liberty.
Overruling the objection, not with objection. No, my objection was overruled. Overruling the,
Marking the
my objection was overruled and marked exhibit. X for
না
identification.
ওকে করেছে S for না exhibit 6 করেছে তো
Yes, overruling my objection, not with objection.
exhibit 6 all right হ্যাঁ কি বললাম Indian Evidence Act code below admitting 6 1872 huh bus and marking the same. Under such circumstances, the plaintiff is granted liberty to produce the certified copy or a true copy of the said deed of power of attorney prepared and compared either by a mechanical process bearing the seal and signature of the authority by laying foundation as to why such secondary evidence was required to be furnished in the proceeding in the absence of primary evidence. If such document is produced, section 54 মনে হয় ওটা একটু রাখো of the Stamp Act
Section
provides that the same shall be accepted and marked as an exhibit. The order impugned is set aside.
Only one thing, Lordship has observed that same shall be marked as exhibit. My Lord, I may have other objections regarding admissibility.
You cannot have certified copy of a deed.
No, my Lord, I can have, my Lord.
How?
My Lord, kindly, my Lord, do not give so much liberty, my Lord.
No,
Let
it's
them
okay.
file, it shall be considered in accordance with law. It should be considered in accordance with law.
চলবে
My Lord, because, my Lord,
if he produces a certified copy, which is an admissible in evidence, a document admissible in evidence, that should be allowed.
Deeply obliged, my lord.
ও দিদি আমার চেম্বারে আছে হ্যাঁ হ্যাঁ
এটা জেরক্স আছে তো দিয়ে দাও না
না কি বললাম certified copy is tendered by following the provisions of section 65
exactly
63 the same
ওটা তো আনতেই হবে।
the plaintiff is granted liberty
we have a xerox
টাইপ কপি জানি এটা টাইপ কপিটা সঙ্গে দেখো
if evidence is tendered in terms by following the provisions of section 63 of the Evidence Act, the same shall be marked exhibit.
Republished.
Yes.
Great. I don't know, all judgments have brought me a lot.
এই নাম আপনার দিয়েছে বলছে তো। Yes, next.
Please, Your Lordship.
I'm for the respondent, Lordship.
Milord, may I
Lordship,
indicate?
Yes, what do you want to say?
Lordship, earlier occasions I was prayed for submitting a opposition, Lordship. I made the opposition, Lordship. If you
Give it to
for
him.
me.
There are no different facts from what are Milord, the papers in the lower
Still
court.
take it, and if you want to use a reply, then I'll adjourn it.
Milord, kindly give me a moment, Milord. I'll just Milord, I don't intend, Milord, to file a reply to this. It is not required. No point, Milord, no point on law has been, because my, Milord, submission is very limited. It is only to 4-5 dates, Milord. The interpretation, because, Milord, what is under challenge before Your Lordship is an order passed under section 7(3) of the Premises Tenancy Act. Milord, closing my defense. I am the defendant there. Milord, I am a monthly tenant in a premises. 2015, a notice was given saying that you have defaulted on two fronts. First, you have defaulted in paying rents, and second, you have sublet the premises to a third party. Milord, immediately after receiving the notice, we give a reply. We dispute these two facts. We say we have given the rents and we are willing to give the rents, and we have not let it out to any third party. Milord, the very next month, we also clear, Milord, there were some months where the amount was before the suit, Milord. Few months, Milord, the amount was pending. We gave a check for all those months, the amount. They received the check, that is on record. They received the check. After they received the check, kindly, Milord,
reject the check.
my learned friend would allow me to, Milord, make my submission.
Sit down.
Milord,
Where is Chakka, please? No, yes.
we issued the check, they received it. Thereafter, Milord, we get a summons that they have filed an ejectment suit. Very interestingly, in the ejectment suit, those 2 points which they had taken in the notice, one of those points have been given a clear go by. That's the amount of rent which was due. The suit was only on the point that you have sublet the premises to a third party. So that point of rental dispute was not taken at all. Milord, after that, we immediately file within 30 days, we file an application under section 7(1), saying we are ready and willing to pay the amount for the month where the rental is due. That was for the month of February 2016. We paid that amount. Milord, this application was filed. So for us, the arrears of rent in terms of section 7(1),
There was no area.
there was, Milord,
Only
1 month.
1 month.
1 month. And that amount was, according to us, then was 1166. 1166 was the amount. We said, this is the arrears of rent. Kindly permit us to submit this. The learned court allowed this application. We made this payment. It is on record. After this, Milord, we file an application on our own volition under section 151, because this had fallen from Your Lordship on the last occasion when I was making the submission, that why was the amount increased to 2,000? From 1,100, Milord, we filed an application under 151, submitting before the court that this amount should be increased to 2,000. The reason I checked, Milord,
Service charges and all that, right?
Service charges, Milord.
Yes.
It is only service charges. They were perhaps wrongly, Milord, instructed. They did not give these charges. 200 rupees lift charge, 198 rupees this. So that is the amount.
That was allowed.
This was also allowed. After that, Milord, I'm not taking Your Lordship through all the dates. Milord, after that, this event, the most important event was in May 2016. This is when we were intimated by the ICICI Bank that the check which we had handed over to the plaintiff in the suit, Milord, was not deposited with the bank. Because we had inquired, this was not deposited. It was not reflected in our accounts. Now, Milord, we file, after coming to learn of this fact,
we filed an application. This is an application under 151 because we could not have thereafter filed an application under 7.1 or 7.2 because we are beyond the 30 days period, my lord, from the date of institution of the suit. So we had no other option, but we filed an application under 151. This application was not considered because it was beyond the period of limitation. Our stand was that this is not an application under 7.1. Application under 7.1 had already been allowed. So we were not required to file a subsequent application. It was only an application under 151 where we made out our case that we had given this amount before the institution of the suit, before the summons were served on us. So this cannot be termed as arrears of rent. That was our case. My lord, by an order of 19th April 2017, the learned trial court refused this particular application. This was refused, my lord. Thereafter, my lord, we nevertheless, my lord, we exercised, my lord, we paid under 7.1c this entire amount which they were saying is to be paid because, my lord, that check was not encashed by them for that pending, my lord, period. Since they did not encash the check, we paid this directly in their account to show our bona fide, my lord. It is not for no other reason. We were really under law, my lord, in my very humble submission, we were not required to pay that because we had given the check much before the summons was received. That's an admitted position. But we made that payment because we did not want to be in default. Plus, my lord, we made the payment for the subsequent period when the suit was pending from February 2016 to April 2017. That was the period, my lord, of the pendency of the suit proceeding. So we paid that.
No, but that also has to be paid month by month, no?
It
You
had to
can't
be,
in
my lord.
area
It had to.
and
It had to.
that
My lord, but my lord, may I very humbly submit the. No, my lord, this is not for because, my lord, the suit was instituted for arrears of rent before the institution of the suit. So that is 7.1. But arrears of rent will not be the period when the suit was pending.
7.1 says month by month, every month.
Month by
No
month,
suit
arrears
default
of.
is a default.
No, my lord, 7.1 has a time frame in my very humble submission, my lord.
No, that's fine.
So, my lord,
But
30
the
days
order
from
in
that.
7.1 was passed saying every month, month by month.
No, my lord, order in 7.1.
Let's see.
lord.
7.1 order.
My lord, it's page 41, my lord. 45, I'm sorry. The typed
Deposit
copy is at
admitted
45A.
along with statutory interest, if any, and the current rent month by month for the month of February,
my lord.
onwards, as for this
Onwards.
own
Risk and prejudice and contentions. My lord, we have made this payment.
you have made it at a go after having defaulted.
My lord, the application was for arrears of rent to be paid. If your lordship kindly takes up once, my lord, 7.1. My lord,
That defaulting you cannot cover up by subsequent.
But my lord, this is not, my lord, a ground for
7.1
lordship.
says month by month, every month.
If your lordship is
Admitted
lord,
earlier and month by month, every month. So you, with your those three, the month before the suit, I can still understand, yes, you had tendered the amount. It is not your job to find out whether they have encashed or not. You had given the rent prior to the suit. So that area I can condone. But what about the subsequent default?
lord, may I request your lordship very humbly, my lord, to take up one section 7. My lord, I may be. My lord, my lord, the notice for the entire proceeding was initiated under 6.4. So your lordship kindly, if your lordship takes up once section 7. When a tenant can get the benefit of protection against eviction. 7.1 on a suit being instituted by the landlord for eviction on the grounds referred to in section 6. The tenant shall, subject to the provisions of subsection 2 of this section, pay the landlord or deposit with the civil judge all arrears of rent calculated at the rate at which it was last paid and up to the end month previous to that in which the payment is made together with interest at the rate of 10% per annum. But this is prior to or till the date of institution of the suit. That is why the time frame of 30 days.
Yes,
this is my limited understanding. Kindly, my lord, thereafter, such payment or deposit shall be made within a month of service of summons. I pause here for a moment. My lord, within a month of service of summons. Summons was served in, my lord, January. My lord, that is when we came to learn that the suit was filed. Within 30 days, my lord, the arrears has to be paid. So that arrears cannot be for a subsequent period, my lord. That is my submission.
What about default in respect of
But
7?
kindly see 7.3.
See, come to
See, my lord, the tenant shall thereafter continue to pay to the landlord or deposit month by the 15th of every subsequent month a sum equivalent to the rent at that rate. We are under that obligation.
This is where
Yes.
you have missed.
But we have, my lord, not missed. We have made this payment. That is what my submission is. But this payment was not made under 7.1. It cannot be, my lord. Because 7.1 is
No,
restricted to
this
30
payment
days.
is 7.1C.
7.1C, my lord, the initiation of proceedings under 7.3 is because of 7.1 violation. That
No.
7.1, my lord, kindly see 7.3. Kindly see, my lord, 7.3. If a tenant fails to deposit or pay any amount referred to in subsection 1 or 2,
Subsection 1 means A, B, and
A, B,
C.
and
of
C.
subsection
A, B, and
1.
C, my lord.
You have defaulted in C.
My lord, C we have paid before the
How
application
you
was
have
filed.
paid?
We paid directly into their account, my lord.
How?
But in one
Every
go.
month.
One go, my
Then-
lord.
Because
That was a
section
fault.
Not for delayed deposit, section 5 will not apply.
No, my
So
lord.
for suppose March, April, May, you play at one go in July
My
or
lord.
June.
My lord.
March default cannot be condoned like that.
Lord, it
Because
was not
section
condoned.
delayed deposit of
My lord,
March cannot be condoned by application of section 5.
my lord, it was
Then
not,
that default.
it was not a default. My lord, 7.3, the application, kindly see, my lord, the application was filed by saying that the previous amount, the original amount for which we had given the check, they say that amount was not given by us.
No,
And they say,
I will condone.
that's the first part, my lord. And second part, they say you have deposited this amount in our
You
bank,
tell me,
my lord.
apart from that amount which you sent to the bank and which was not encashed,
My lord.
after the suit proceeded, did you deposit month by month, every month or no?
My lord, I have to be fair. We did not.
Then
We
it
did not.
goes-
That's the case, my lord, which I'm running. We did not. But kindly, my lord, the application under 7.3 was filed on 10th of July 2017. They filed that application under section 7.3 for striking out our defense. This was filed on 10th of July 2017. My lord, we had made a payment for February 2016 to April 2017 in one go.
On
My lord, this was paid on 20th April 2017. Along with the interest of 10%, we have given the entire sum. They immediately write a letter that you could not have given this amount to us without the leave of the court.
correct.
We say 7.1 I could not have filed subsequently because the 30-day period is given. I can file 7.1 only once. The subsequent 151 which I had applied for because I wanted to make the subsequent payments was not allowed. But I wanted to make that payment. It is not that
It is not about you wanting at any stage, it's wanting at the appropriate stage.
my lord, I wanted to make that payment at appropriate stage because kindly see, I have made this payment for February to April 2017. February 2016,
In April. So
But-
for February, you are in default.
my lord,
Second
the
default
application,
happened.
the
Then
second
you should
default,
have gone and asked for permission.
my lord, may I very humbly submit the second
Section of
application.
notice could have been given to you under 7.2. You did not do that.
My lord, we wanted to make that payment by our second application, which we had filed in June of 2016. We had filed an application. And the reason we had filed that application is because they were not accepting the monthly rentals from May 2015 onwards. Since they were not accepting, we filed this application. This was rejected, my lord. This was rejected by saying this is beyond 30 days period. That is a very important order, my lord. But
You didn't
ideally, an
challenge
immediate
that
revision
order.
should have been filed against this. It was not filed. That is where my difficulty lies, my lord. They should have immediately come up against this
So,
appeal, this
7.2
order.
gives you one default, you can pray for extension, and extension of 2 months is given. So
My lord,
you could have
7.2,
gone
nothing was filed.
Then
It was filed under 151, and thereafter, my lord, since it was rejected, the plaintiff filed an application under 7.3 saying you close their defense. Our stand there was that this is not amounting to areas of rent because we have made the payments. Today, my lord, when they give us notice under two broad heads, one being that you have defaulted in paying the rentals, and second being that you have let out the property to third parties. My lord, we are in possession of the property. There's no third party involved. There is an office running. It's an office space, my lord. We are operating from that space. So then they give up that angle completely. And they say that we will not take this amount because it's a notice under 6.4. So reasonable requirement is their case. We have a very good case on merits. But today, if our defense is struck out, that we will not be in a position to present our case before the court. That is the difficulty. And we are not shying away from making this payment. The only difficulty
the
which
law has been now after Chamaria's judgment, what can be done?
my lord. That's on the condonation of the angle of condonation.
Now your
Cannot be condoned.
deposit for February to April is a delayed deposit.
February to April, yes, my lord, but that was because
So that delayed deposit, if you voluntarily, how can that, just because you sent it to their account, that has to be
with the
condoned?
interest, but
Then-
that was not condoned, my lord. That is the difficulty. Kindly see what has been made, my lord, the press, because we have, my lord, written to them that you did not accept this payment. We wanted to give it to you. You did not accept this payment, and that is the reason we have no other option but to deposit it in your account. So we are not really in default. And 7-1 could have been, my lord, allowed only once.
No, forget
7-1
about
could have been allowed
7-1.
once.
We are not on 7-1. You could have gone in 7-2. And asked for an extension when you failed the first installment of February.
My lord, 7-2 in my very respectful submission would only operate if, my lord, the amount is not quantified.
No. And if there is a delay,
But 7-2, my lord, the first provision, my lord, subject to correction by your lordship, my lord, it states that if it is an application for determination of the amount of rent payable, if the amount is determined and it is agreed by the parties, then 7-1 applies. Within 30 days, you have to deposit this sum. If the amount is not quantified, there is a dispute, then we file an application before the court saying you kindly determine the amount and give us time. We will deposit this amount.
all
But
right,
here our case falls under 7-1
all right.
because the amount is quantified and that is not disputed by the plaintiff. So today, my lord, we wanted to make that payment under 7-1. Time frame of 30 days was, my lord, what we had. We made that payment. That application was allowed. Subsequently, when the
It
state
is that 7C, 1C, you have not complied with
to
7-1.
continue with the payment, my lord, the
Yes.
tenant shall thereafter
Then-
continue with the payment
Then
to pay the landlord a deposit with the civil judge month to month by month, by the 15th of each succeeding month, the sum equivalent to the rent at that rate. My lord, this continuation, if your lordship once takes up, my lord, the 7-3 application, this is not their challenge. This is not their challenge. The challenge is that you did not pay that original sum which we had given by check. And that is where we are ousted, my lord. That is where the application under 7-3 is allowed. Kindly take up that application, my lord, under 7-3 once. Your lordship will find that at page 94.
yes,
Kindly see page 94 is the application under section 7-3. Kindly see paragraph 4 at page 95, my lord. That is the case they are, my lord, seeking to run before the court. Page 95, paragraph 4. And thereafter, over the page, my lord, at paragraph 8. They tried to make out a case in paragraph 9, but their case at
One
paragraph,
minute,
my lord, I said that.
where is the order impugned?
My lord, before that, my lord, may I only indicate paragraph 14 once at page 98.
Yes, I've seen paragraph
My
14.
lord. The order impugned, your lordship will find, my lord, at page 111. Your Lordship will kindly see page 112, the third paragraph, middle of the paragraph. My Lord. $21,000. 33,456. This is the first amount.
Yes.
But this was in relation to the first amount, saying that this amount which was actually in dispute was never paid by them, which they term as arrears of, my lord, rent. Now, my lord, the only reason we could, my lord, we found, my lord, because this was also indicated and we are under instructions, the reason why we did not make that payment till April 2017 was because, my lord, our application, the second application under 151, by which, my lord, we wanted to make this payment, was decided on April 19, 2017. The order is at page 61 of the.
With regard to that, those 3 months.
So this is with regard to the subsequent period. Because we wanted to make that payment, because this was to be decided whether this can be done in a 151 petition or it can be done, it cannot be done under 7.1. The amount is decided, so we cannot go under 7.2. We stand remediless, so we come under 151. This was rejected because, my lord, the court held by this order 3 things. My lord, the condonation of delay in filing the written statement was allowed. The first application under 151 was allowed, and the second application by which, my lord, we wanted to make the subsequent payment was rejected. Your lordship will find this at
Is
page
the
61.
subsequent payment for the month of May 2015 to January.
May 15 to 2000, my lord, that is the period. We
Yes,
wanted
now
to make
what
that pay.
Payment from February you paid on the basis of the 7.1.
My lord, February paid on the basis of 7.1. This application we were waiting.
March, April, May, those subsequent, the post.
But we were waiting for this application to be decided, because if this was decided, my lord, we would continue, because this would have been in the nature of an order under 7.1, where, my lord, 7.1C would operate.
7.1 has already told you the order that you pay the current rent.
Lordship, but the
Current rent
dispute
had
remained.
to be paid as per 7.1C.
It had to be, my lord.
Whether you are in arrears of that or not is the issue. First 3 months, I can condone saying.
Not first 3 months, my lord. February, March,
No,
May
March to
2015.
16, May 15 to January 16, I can say at best that this is not arrear because you had tendered the amount.
Then 7.3 would not lie, because 7.3 has been decided on the, my very humble
But what
submission is
about the
this.
subsequent default?
The subsequent, we have paid immediately after this order, because according to us, my lord, this order of April 19, 2017 is, my lord, the crystallization point from where
Where is the order of April?
my lord, page 61, my lord.
Again, that defense will be struck out.
Page 61 onwards, my lord. This was the. My lord, your lordship will kindly note page 62, the second paragraph onwards. This itself was not allowed. Because it was in the nature of a modification, my lord, for the payment. That modification from 1,000 to 2,000, this was allowed by this order.
All right.
So then we knew what exact amount we have to pay. But by that time, my lord, 7.1, the time frame under 7.1A had expired. But we made the payment, because by then that amount crystallized, because that application under 151 was allowed by this order. Today, my lord, if the defense is struck off under 7.3, that would be, my lord, draconian for the defendants in these facts and circumstances, because the arrears of rent, and my lord, we undertake to pay the.
No, May 2015 to January 2016 may not be arrears if I accept whatever you say.
My lord,
Even then, the subsequently you have not, you failed to comply with 7.1C.
my lord, 7.1C, because this application was pending
Oh,
from March
that's not
2016.
how- Yes, let's see what they have to say.
My lord. My lord, this is in a nutshell my case, my lord. Very deeply obliged.
Yes,
Yes. Sure, I have no more submission, Lordship.
huh? Yes,
You kindly see the opposition, Lordship.
yes.
Page number 3, paragraph 6, Lordship.
Yes, what do you want to say?
Lordship, kindly peruse the page number 4, paragraph 13. That with reference to the contents of paragraph 19, it is that the plaintiff opposite party acted in consonance with law in refusing the.
I tell me one thing, that check did you refuse?
Yes, Lordship.
How? On basis of, how will I know that?
Next page.
Have you said it in your
Lordship,
application?
kindly peruse
Yes.
the page number 112, Lordship. Improved
All right.
order. The code of observation, Lordship. Kindly.
Where is your 7.1 application?
My lord, 7.1 application, your lordship will find at page, my lord, 41.
এই,
41.
এটা তো খুলে যাচ্ছে, এটাকে একটু ঠিক করে ইয়ে করো, ভালো করে বেঁধো। Page
41, my lord. Paragraph 2, it's only for the month of February.
Where was the check tendered? Where is that?
My lord, it's page 39 and 40. The typed copy your lordship will find at page 38A.
So, but where is the copy of the check?
No, the copy of the check is not annexed here, my lord.
No.
No, my lord. The receipt is there, my lord, at page 39 and 40.
That is the postal
The
receipt.
postal
So
receipt,
we
my
do not know what it is, because you in the 7.1,
Lordship,
you have not said that.
lordship.
That they
7.1,
said
we have
that-
not said that.
Then,
No, that is subsequently in the 151 application, the entire facts are stated, my lord, that's at page 46.
yes,
There-
but whether that check was ever sent is the
It was,
question
my
of
lord,
doubt.
it was. Because in their opposition, we have indicated, my lord, that this was sent and they refused to accept it. Kindly see, my lord, page 49, it starts the application. And your lordship will find at page 50 is our averment, paragraph 3. Also, my lord, there's a confirmation from the bank at page 55. That's the bank document, my lord, where the bank says this was
Are
tendered,
you
but
disputing that this check was ever sent to you?
no, my lord, they have not disputed.
First time check was sent, did you dispute that?
7161. Lordship, page number 58A, Lordship, after 23 days of receiving the safe check of the
Paragraph, page?
That's an admission, page 58A, my lord.
Which by which?
The first two lines, my lord, it starts from the previous page. My lord, 57A is a typed copy, paragraph 9, my lord. Also, if your lordship is pleased to consider page 55 once, that is the document from the bank. Check issued and not presented till date, my lord, page 55.
No, check is there. No, this is subsequent check.
My lord, page 55 is the confirmation from the
65,
bank.
65?
And that's a subsequent, my lord, payment, 33,456. No, that's a subsequent payment for the period from February 2016 to April 2017. The first confirmation is, my lord, there at page 55, where the bank has said that this has not been deposited. The check details are
This 33,000 was handed over to the advocate.
33,000 was given to the bank account, my lord.
No, see paragraph 14. Of your revisional application.
My lord. Kindly give me a moment, my lord. I stand corrected, my lord. Page 64 is the document. My lord, last line, this pay order is handed over to your lawyer. My lord, there are two dates. My lord, kindly, this is April 20, 2017, where we hand over a pay order to the lawyer. The lawyer does not accepts but does not deposit. My lord, in May, we directly deposit this amount in the bank account. That's page 66, my lord. This is intimated at page 67. My lord, you will find at page 67, we have intimated this. Second paragraph, page 67, my lord. 18th May 2017. And this deposit is, my lord, for the first period, May 2015 to January 2017.
And
January
this
2016.
separately, that amount of 21,000 has also been sent.
Also sent, my lord, directly.
Or
This is in the bank account.
33,000 includes all.
My lord, 33,000 is for the
That
subsequent
period.
period, and this is for the previous period when they did not deposit that check, my lord. This is for that period that we have already deposited in the bank account. This is what they say you could not have deposited without the leave of the court. This is where, my lord, the 7-3 was filed, and this is where the 7-3 was decided. My case is this amount we had already handed over through the check before the institution of the suit and the service of summons. So 7-3 is in a wrong premise. That is my submission, my lord. Because this is the basis of that 7-3. They say you could not have deposited this amount directly in the bank. Because the pay order for the subsequent period, my lord, we have handed over. They have not deposited in the bank, my lord. They have kept it with themselves. This we have deposited directly. They filed 7-3 saying this could not have been deposited without the leave of the court.
No order in the, there is a no duration of the order, lordship.
That's the case.
The money.
I completely agree with my learned friend. That is the case they are running. That they could not have deposited this amount, May 2015 to January 2016, for which we had given a check before the suit and they did not deposit it.
The money illegally, lordship.
That's the case, my lord. They had, according to them, this is illegal.
No, order of the court may not be, but the check was sent to you.
Yes, lord.
Your case is that they should have ascertained whether the check was sent to you or not. You encash the check or not before filing 7-1. That is your case, isn't it?
So we refuse the check. After that, we file a 7-1.
They refuse the check.
Where is the refusal? Where have you said that you refuse the check?
Check is with them, my lord. They could not have.
I have no instruction, lordship. Where is the check?
Where have you refused the check? In your objection, you have said it was left with the receptionist. We did not know about it.
And kindly see page 55, ICICI banks say that this particular check has not yet been presented to the bank.
But your duty was to find out earlier.
My lord, in my very humble submission, my lord, the moment we hand over the check and they receive it, that is where my obligation as a tenant, my lord, ends.
That's true.
Then it is their obligation whether, my lord,
Subsequent default, that is where you will be stuck.
subsequent to 7-3, I completely agree with what is falling from your lordship, but 7-3 has not been decided on that premise, my lord. My prayer today with your lordship is 7-3 is on a wrong premise. You know, that could not have been termed as arrears of rent because I have already discharged my burden, my obligation under the law. 30 days I have paid that February.
33,000 also in the 7-3 court has rejected.
My lord, they have.
Then
That is, my lord, in line with the subsequent 151 application.
true, but that has also been rejected.
But my lord, that is on
All right, CAB.
lordship.
এটাকে একটু সেলাই করাটা ভুলে যাচ্ছে। Hearing concluded, CAB.
My lord, do we file a short notes, my lord? Is it required? My lord,
You can.
we will, my lord.
তাহলে hearing concluded. তারপরে একটা how long will you take? CAB টা করো না, hearing concluded. List on.
But may we do it by Monday?
Can you? I can give you a little more time, no issues.
We can do it by Monday, my lord.
On you want, then they also want to file, you want to file any written notes?
No.
List on 20th June under the heading to be mentioned. 21st করে দাও, এই সোম মঙ্গলবার ভীষণ ঝামেলা হয়। To be mentioned for under the heading for orders
I'm deeply obliged, my lord.
and for filing of written notes.
Lord, at the very outset, my lord, I beg your lordship's, my lord, apology. Lord, 2 pages have been annexed, my lord, which are not in connection with this case, my lord. Page number 2.
What's the case?
My lord, I'm challenging an order passed under order 39 rule 7 of the CPC. I'm the defendant, my lord. Dispute about, my lord, 5 feet passage which I claim to be of mine. They filed an application for under Order 39 Rule 7, my lord, regarding certain, my lord, points. Some points are allowed and some are rejected. My lord, kindly comes to the impugned order once.
One, 4 and
1,
5.
4 and 5. I am not concerned about 1. I am concerned about only 4 and only 4.
Which paragraph?
At
Which
page 44. For, my lord, to note the nature, character, and condition of the C schedule property. Now, my lord, 2 and 3 have not been allowed. 3 is to identify and draw a rough sketch map of C schedule property is that passage.
Yes.
With the, my lord, unless and until, my lord, C is identified, my lord, how can, my lord, the nature, character, and condition of C schedule property can be, my lord, inspected by local investigation?
C is the passage which there
This is the passage they claim to be common passage. Now, my lord, I claim to be of my property.
local features of C schedule. Why cannot
Well,
be
C schedule property, my lord, identification, my lord, cannot be possible because boundary wall, my lord, cannot be inspected by local investigations, my lord. There is plethora of decisions as well.
local inspection?
Local inspection, Order 39 Rule 7, my lord.
Boundary dispute.
Boundary dispute.
Yes.
Cannot be, my lord, inspected by local investigation. It was, my lord.
Boundary dispute is a case of local investigation under Order 29 Rule 9. Issue is that if there is a passage, why the nature and character cannot be seen? What is visible to the eyes? Local features can always be seen.
My local, with regard to my lord, local features, my lord, can be seen, my lord.
Dispute with regard to measurement and stuff, that may not be done. But by local inspection. But why cannot they just go and see the passage?
Now, my lord, C, my lord, to identify the C schedule property.
That is not there.
That is not there, my lord. Unless that is identified, my lord, the nature and character, my lord, cannot be ascertained, my lord.
C schedule, how is it described in the plaint?
Now, kindly says, my lord, plaint, my lord, starts from, my lord, page 24.
The court is right.
Page 32 is the C schedule, my lord, as mentioned in the plaint. Five feet wide common passage which stands on the western side of the premises holding the said common matter.
See and come. Because what is the reason for asking for local inspection?
Their prayer is that, my lord, to determine the, my lord, measurement of the.
There is no prayer for measurement.
Yes, there was prayer that was not granted.
So that is not granted.
That
Only
is not
nature,
granted.
character and condition. That has been allowed. So that case can be seen. without any measurements.
My lord, a question of identification was also before the trial court below. My lord, that was not being granted. My lord, unless and until my lord, my contention is that, my lord, unless and until that is identified, my lord, the
That would
nature.
have gone against you if it is a direction for identification was given. Because
lord,
when you have raised a boundary dispute,
I have not. They have raised. They have.
the boundary
They have
dispute,
raised the
you
motion.
are claiming title.
I am claiming like.
So, in all practical purposes, Order 26 Rule 9 should be the correct approach for demarcation of that passage.
Yes,
They
yes,
have not
for my lord, order 39 rule 7.
that. Court has said that point number 4 is allowed to go and see the local features of a passage. If they come and say there is no passage, no passage. That doesn't mean that it is deciding whether the passage is there or not. Because you have installed the iron gate.
Yes, that is my lord, that is the statutory site space of my construction.
So whether the gate is there or not, that they will go and see. Nothing is there.
My lord, the question of gate, my lord, that has not been mentioned in the my lord application also.
All right. It has been mentioned in the application. Come to, I have read it. Come to paragraph 2, 4th line.
My lord, page 44, my lord, kindly see the points of my lord.
42.
42 is their claim. Now, my lord, kindly comes to schedule for local inspection, my lord. Page 44. 1, 4, and 5. There is no question of holding number 50, my lord. I don't dispute that is their property.
Take down. The petitioner is aggrieved by an order passed by the learned Civil Judge Junior Division 5th Court at Howrah, dated June 17, 2022. Stopped by the order impugned an application under Order 39, Rule 7, read with Section 151 of the Code of Civil Procedure, filed by the plaintiff.
By the plaintiff.
Entitled suit number 198 of 2013 was partially allowed. The points for local inspection which were allowed are as follows. 1, 4, and 5. 1, 4, and 5. AJ, page 44. The learned advocate for the petitioner submits that unless and until the common passage is identified, measured, and demarcated, the question of inspecting the local, the nature and character and condition of the sea scheduled property would not be allowed. It is further submitted by the learned advocate that identification of a passage when there is a boundary dispute cannot be done by way of local inspection. Next paragraph. Having gone through the order impugned, it appears that the learned court below was conscious of the fact that a boundary dispute with regard to A, B, and C scheduled property as enumerated in the plaint could not be ascertained, ascertained by appointment of by a local commission. Rather, an expert commissioner was required to make a local investigation. The learned court also found that the defendants did not deny the existence of a passage but whether the C scheduled property was actually a part of B scheduled property or not was a matter of trial and which could not be ascertained by way of local inspection. In the opinion of this court, the learned court was correct. The court just allowed the commission on the points which are namely the identification of the A scheduled property, the nature and character and condition of the C scheduled property, and local features, if any. None of these points amount to the local inspection on the above mentioned points would not amount to fishing out evidence Rather, the condition of the passage, if any, the condition of the passage and the local features which are available in the A schedule property shall be seen, so that those facts are before the court, and no mischief can be, and if any mischief or damage or destruction is caused to the said property during the pendency of the suit with regard to the above points, the court would be in a position to refer to the same. Under such circumstances, the application does not merit any consideration. The order impugned is upheld. Disposed of.
Great.
Please, your lordship, my lord, this is my civil revisional application. I'm for the defendant petitioner. This is from an order whereby, my lord, liberty has been granted to the plaintiff to institute a fresh suit, allowing their application for withdrawal and then for liberty to file fresh. But then, my lord, kindly sees the order, the impugned order. The learned judge has proceeded on the basis as if making an application for grant of, my lord, liberty to file afresh is an inevitable consequence if somebody asks for withdrawal of suit. Relying upon an order of in a previous round of litigation of this honorable court, which in my respectful submission does not say that, or it can't say that, because that goes against Order 21, my lord, Rule 1, sub Rule 3.
Will be allowed on after examining plaintiff.
Yes, Lordship, because on doc, the plaintiff has to be examined before Lordship withdrawn.
The petition has been allowed. Kindly sees the observation, my lord, the reason, para 5, from the observation of the Honorable High Court, with its order in CO 1919 of 2022, it is evident that the Honorable Court was pleased to set aside the court's order with observation that withdrawal of the suit with leave to file the suit afresh is inevitable consequence. That was perhaps not the correct interpretation of the High Court order. I'll take your lordship, my lord, to the High Court's order, which is at, my lord, page 20 of the petition. Initially, the plaintiff had filed the application for withdrawal of suit. Though there was no prayer, my lord, for liberty to file afresh, in the body that averment was there, on the ground that the suit is defective. That was rejected by the learned court below, but then the suit was directed to proceed. There was a civil revisional application filed in which, my lord, this order of 15 September 2022 was passed. And the observation which has been relied upon by the learned court below is in the second page, second paragraph.
Come to the paragraph, second paragraph of page 21.
Yes. In the context with the copy of the, in context with the copy of the petition dated 16 March 2019, it appears that the withdrawal of the suit for the reasons mentioned therein, with a prayer for obtaining leave to file suit afresh, is inevitable consequence, which is conspicuously evident
from
the text
of
the petition. So the petition now, my lord, kindly see why this, on what was the reason, my lord, for this observation. My lord, kindly sees, my lord, page 12. Page 12, my lord, is the petition. The reason why this observation was made by the by the on the previous round of the litigation. But English translation is there in my lord's we file, my lord. Possibly it's I can. Huh. My lord, I can read out, my lord. May I? Shobinoy Nibedon. Sorry. Where's the order? Last order. The order to put
Yes.
Now, my lord, apropos this, lord, so this petition only stated that the suit is defective. In the body of the petition, there was an averment that they would like to file a fresh suit, but in the prayer, only prayer made was to liberty to withdraw the suit. Now, apropos this, my lord, 16 September, though the order is not annexed, 16 March 2019 order, my lord, kindly sees the impugned order, paragraph 4 that has been quoted. 22nd April 2022 order. From the record, it transpires that the order number 22, dated 22nd April 2022, had rejected both the applications of defendant.
That being the position, no further elaboration is necessary.
Petition. However, the court petition of the plaintiff bears no specific cause for formal defect or reasons for the same to be filed at fresh, had rejected the application dated 16 March 2019. So the learned court was of the view that there was no reason given or no particulars given as to what was the formal defect in the petition for withdrawal. Now, in the High Court order, your lordship kindly sees, in the High Court order, my lord, may I place the operative part of the order, page 21, fourth paragraph, my lord, the last but one paragraph. The revisional application is disposed of upon setting aside the impugned order dated 22nd April 2022 with a direction upon the court below to rehear the petition filed by the opposite party plaintiff on 16 March 2019 in context with the reasons disclosed in the petition, providing sufficient opportunity of hearing to either of the parties to this case, but without granting any unnecessary adjournment, preferably before the next date of hearing. Now, my lord, the next page, the first paragraph. Liberty is granted to the opposite party to seek leave for filing supplementary affidavit in connection with the original application proposing withdrawal of the suit. Basically, to disclose the actual reason, actual defects for withdrawal of the suit. No.
That was not filed, lordship. Kindly consider, lordship, the last paragraph when, lordship, the court, lordship, earlier occasion direct the learned trial court, lordship, to disclose in the petition providing sufficient opportunity of hearing. Now, lordship, at the time of hearing, lordship, it was read before the learned trial court, lordship, the suit is regarding, kindly consider, suit is regarding, lordship, unregistered partnership deed. Now, lordship, in connection with partnership deed, lordship, I am claiming, lordship, some accounts, lordship. The suit is therefore suit is maintainable, but the earlier occasion in the prayer, it was claimed, lordship, the dissolution of partnership. Actually, the cause is, lordship, to withdraw the suit, to, lordship, file appraise with the suit for account.
Gupta gave you an opportunity to file an the reasons, better reasons.
But, lordship, court was satisfied, lordship, regarding the petition. Kindly consider the petition, lordship. In the petition body of the application, it was clearly stated, lordship, the defect. And that at the
Where
time,
is the defect stated?
what is the defect? It was not stated, but in the application.
The defects you have stated.
Yes, lordship.
No, but when the High Court gave you an opportunity, you filed that.
Then, lordship, I will be, as the court was satisfied, lordship, that was not required, and court.
No, how the court was not satisfied? If the court was satisfied, then High Court would not give you.
Yes, lordship, I am taking instruction, lordship, regarding that whether the such application supplementary affidavit was filed or not. Court not to try.
See, withdrawal and filing afresh, everybody has the right.
Right, at any stage.
Cannot be stopped.
Any stage.
My lord, only thing, my lord, here, the court below has proceeded on the basis as if such liberty has already been granted by the High Court.
No,
where the High Court had directed specifically to hear both the sides and for them to file a supplementary affidavit to disclose better reasons. My lord sees order 21 rule, my lord, rule 1 sub rule 3 once, my lord. If I may, my lord. Where the court is satisfied, my lord, may I please?
Yes, sufficient grounds. You file your affidavit. Yes, take down.
Yes, Lordship. Kindly consider Lordship, even after Lordship sub-rule 3, which states that if the court is satisfied, even after Lordship the supplementary affidavit was ready, it was not taken into record. If your Lordship direct, we can file at the.
With
Yes,
your
sir.
reasons,
Yes.
why the formal defect should be.
I'm grateful, ma'am. In case they file a supplementary, liberty may be given to us to use a written objection to the
So
supplementary.
it will continue.
But it depends on whether
Everybody
they
has a
For
right to
withdraw
withdraw.
Lordship, their objection is not necessary.
For
If
withdraw,
court is satisfied,
when
as
my
per
lord
sub-rule
discretion
3,
Be
is
satisfied.
court
has to be
satisfied, Lordship,
court was
they have-
not satisfied on the basis of
Yes.
this petition on earlier occasion. Now because high
Now that is why High Court
Yes.
has given them an
Supplementary.
opportunity to improve,
yes.
but no question of any opposition. The petitioner, who is the defendant in a suit in title suit number 11 of 2017, pending before the learned civil judge, Junior Division Theodore Nodia, has preferred this revisional application being aggrieved by an order dated April 5, 2023. By the said order, the learned court below opined that the plaintiff will be allowed to withdraw the suit with liberty to file afresh upon examination. Next paragraph. The learned Mr. Bhattacharya, learned advocate for the petitioner, submits that once the learned court below had rejected the application, it amounts to dissatisfaction of the court with regard to the grounds for withdrawal. However, the matter was revived when the learned coordinate bench of this court had passed an order in CO 1910 of 2022, dated September 15, 2022, granting the plaintiff leave to move the learned court below, seeking liberty to file a supplementary affidavit to the application for withdrawal, disclosing the reasons. In the opinion of this court, once such liberty was given to the petitioner, the same amounted to an indication that the reasons should be disclosed in further detail. Although withdrawal of a suit, right to withdraw a suit and file afresh is available to the plaintiff, the same said procedure can be invoked and allowed upon the court being satisfied that the formal defects would either result in failure of the suit or
Sorry.
or there were sufficient grounds for the plaintiff to withdraw the suit and file afresh on the same cause of action. Next paragraph. And it is agreed that the learned coordinate bench found that withdrawal of a suit would automatically result in a consequential remedy of a liberty to grant, consequential liberty to file afresh on the same cause of action. Yet when when the learned court was of the view that a supplementary affidavit disclosing better reasons should be filed, the plaintiff should avail of such opportunity and file the supplementary affidavit disclosing better reasons in the court below, and the court below shall then proceed with the prayer for withdrawal in terms of Order 23, Rule 1(3), and grant pass necessary orders, including an order of pass necessary orders on the basis of the prayer made by the plaintiff. Yes.
Well, the impugned order
Let
needs to
such exercise be completed within a period of.
The matter was fixed for Lordship on 2nd June, Lordship. It is now it's fixed on 15th.
My instructions are now fixed on 15th September.
You file it.
I will file a Lordship put up petition. By put up petition, Lordship, I will communicate the order.
The plaintiff shall be at liberty to file the said supplementary affidavit by way of a put up petition and pray for preponement of the preponement of the suit, so that necessary orders can be passed
Well,
by the learned court below.
Well, the order possibly needs to be set aside, my lord. This is allowed.
Order impugned,
that
is
will
modified
lordship-
to the above extent.
Yes, grateful. Set aside lordship and wants to lordship.
চলো ডাকো।
Before raising my possession on Saturday itself, my lord, if
I was sitting at 10:30. That was the time for mentioning. Please, have you checked up? It is an appealable order. Take down the order. Yes, the order impugned before this court is an appealable order. Petitioner is granted liberty to withdraw the certified copy of the order impugned and upon furnishing photocopy thereof. The revisional application is dismissed as not entertainable. তাহলে উপরে লেখো liberty is given to correct the cause title. Next.
Short pass.
Short today is 3:30.
Just is coming on.
All right, short pass over. রাখো এলেই নেবে. No caveat.
No.
এই দিলি ওনাকে ওই সাইড দিয়ে ওটা দিয়ে দে ফাইলটা কারেকশন করে দিবে।
Lordship, I'm for the petitioner.
I'm praying for short pass. 5 minutes. Short pass.
What is the matter?
Lordship, it's an incident application filed against an order of 14 February, which was passed by the learned additional district judge in Third Court, Barakpur. And it was in miscellaneous appeal against the order dated 23rd March, passed by the learned civil judge.
All right, no, wait. Your appeal has been dismissed.
Lordship,
All
my
right, come back, let him come.
okay, Lordship.
Wait for 5 minutes.
Lordship.
Next.
Well, preemptor is the petitioner before your lordship. Preemption application was allowed by the learned judge and civil judge junior division, and my lord directed the petitioner to deposit. Petitioner directed the opposite to permit to withdraw the money. Thereafter, my lord, opposite party PMT filed an appeal before the appellate court. Appeal court set aside the order of the preemption application only on the ground that the Al-Asad High Hospital. But my specific case was that the site tenant, they are stranger. We are the co-sharer as well as the landowner, my adjoining landowner. Now, my lordship, the appeal court order only on the basis of the eye hospital. By this issue, my lord, is still your lordship, an another case is still pending for my lord before the larger bench.
That is about co-sharer. Whether a co-sharer is
In this case,
apply, will apply.
yes, in this case, submission of 3 points. One co-sharer and adjoining landowner, and another
You are claiming under in what? As what?
adjoining landowner as well as co-sharer.
Cannot.
Thereafter,
Barashat Eye Hospital is with regard to the
Short deposit.
Justice Bhattacharya has referred it on the ground that co-sharer, Barashat will not apply to co-sharer.
Then,
Will not apply, yes.
then this case is in my favor because
Where? Show me that it was
yes,
dependent
yes.
on co-sharership.
your lordship, is the trial court order. The documents filed by the my lord, internal page, my lord, and the my lord, the innocent miscase being and the same is
1 minute.
Illustrating the appellate court judgment only, my lord, did not deposit the entire consideration.
This is also wrong, non-notified co-sharer 3 years.
But
And barred by limitation.
no, in this case, well, but by limitation, but the only point which has been raised by the student, my lord, your
Whatever point, your application was barred by limitation anyway. Non-notified co-sharer is 1 year.
but when
Article 97.
but in this case, my lord,
What was that? When did you file? Where is your preemption application?
my lord, revision application not annexed here, my lord, only I have judgment, only when I have judgment 2, there is the direction for to deposit the,
Where is your preemption application?
my lord, here is any, no preemption application is here.
How can you file it without the preemption application?
My lord, actually, my lord, my lord, really annexed the only 2 judgment, one civil court judgment, civil judge junior division, as well as my lord, appeal court judgment, miss appeal. And my lord,
That is all that is
no,
necessary
no,
for
no, no, my lord,
identification.
no, my lord, but my lord, here only, you also can see the only trial court order where it has already been decided, only co-sharer, already adjoining landowner, as well as consideration.
It cannot be everything.
Rossi died, Lord.
When did you file? When was the transfer and when did you file the case?
Well, actually, my lord, land was,
You have suppressed everything intentionally from the revision.
no, 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 my lord, in this case, my lord, it was, my lord, I have purchased the land, 25th
When
June 17,
did the sale take place?
29 January, March 2011.
29th March 2011.
My lord. And he filed this application.
You filed the preemption application on?
এটা আছে এর কাছে না নেই না shoot number 12 miss case number 20 of 2012. That is more probably within 1 year. PMT details. You will see miss case.
1 minute.
Mind rightly but by limitation, but that point mind rightly
It is within time.
29 March and 9th March. Issue and when you logically see the large Lanet civil judge junior DSO might discuss the all points regarding co-share and adjoining landowner as well as all, but regarding market price, short deposit.
But the Barashat Eye Hospital said that. What would the learned appeal court do? Now,
but in this case, position has already been delivered as well as the which was passed on before that. But when you lost it, but it is the judgment you lost.
Where is Justice Bhattacharya's order?
Bulakundu. But that order is not.
Nothing you have come by,
No,
you
no.
moving a matter. What is this?
But I know, my lord, that point will not be raised before this because you are, my lord, only your lordship appeal court judgment also can see for a moment. Your lordship, can you see the
And if I have to admit, I have to refer to that decision where another coordinate bench has referred the matter. What his lordship has held, I need to record. Service upon the opposite party, affidavit of service to be filed on the next date. The subject matter of the property sought to be preempted, which is a part of miss case number, which is the subject matter of miss case 20 of 2012, which was decreed by the learned civil judge, Junior Division, Bonga, and the subject matter of appeal
30 August.
being miss appeal number 01 of 2017 shall not be alienated or transferred by the judgment and order dated August 30, 2022, passed by the learned civil judge, Senior Division, Bonka. Miss appeal number 01 of 2017 was allowed on the ground that short deposit of the consideration money with interest subsequent to filing of the preemption application would be hit by the decision passed in Barashat Eye Hospital. The petitioner submits that being a co-sharer, as per the decision of another coordinate bench, the decision, the principles laid down in Barashat Eye Hospital would not apply, and the learned coordinate bench has already referred the matter to a larger bench. ওই যে alienate ফেলিনেট বললাম না 31st up to 31st August 2023. Let the matter appear in the monthly list of August under the heading motion. Yes.
Well, 30 August order may be stayed, my lord.
What state? I've said it will not be alienated.
No, I leave it.
31st August interim order or monthly list of August motion.
I am praying for adjournment for a week.
Not this week. Which means Monday. Can you do it on Monday?
The problem is, during pendency of this civil revision, my client, without consulting me, has filed a modification application of the impugned order before the learned court below. Now, if it is rejected or
No, then withdraw this. Because if it is rejected, this will not survive. You have to
directly
that
affect
order.
my, that is why kindly give me 1 week time, and if it is necessary, then after that I shall.
All right.
Great.
Come back on when then?
1 week, Lord, kindly.
তাহলে ওই the 25th, 26th. Passed over matters, people have come. Your other side has come. 26 তারিখ mark করে রাখা যাবে না?
Lordship, I'm just led by Mr. Shuddhananda Banerjee. He's on his way, he's on his leg. Just 2 minutes, Lordship. I'm just.
All right.
Grateful.
My item number 20 was passed.
He's waiting. Later. Yes.
Item number 20.
এটা দেখো
20.
Yes.
Me a letter stating that it is an application under SAFE, but under 8, Lordship, but it is neither a section 8 application nor a
What is
section.
what is the order
Lordship,
impugn?
no, Lordship, I'm coming, Lordship. Thereafter, Lordship, an ex parte arbitration proceeding started without any intimation from the arbitrator. Section 17 application was filed, order was passed, and in the section 17 application, my direction was passed to stop my salary. I got this intimation from the bank. After my salary was stopped, I went to the bank manager order of section 17 application stating that my salary was stopped. Thereafter, Lordship, I wrote a letter.
What is the order impugned?
Lordship, I'm not against a particular order.
Then what
Lordship,
what are you
coming, Lordship.
against?
I'm coming, Lordship.
Yes.
Lordship, thereafter, Lordship, I wrote a letter to the respondent as well as his advocate stating that give me the copies of the arbitration proceeding, the venue, the next date. I will participate over
So you have
Yeah,
to
no,
ask before the learned arbitrator.
Lordship, yes, Lordship. Kindly come to page 15. Arbitrator never contacted me, never gave me any letter. I only know the name of the arbitrator, no address, nothing. How do I contact him? Nothing is on record.
But this is then how can I pass an
Also, I do
order
not have
on
any
my
other-
private meeting?
I do not have any other opportunity. Lordship. If I go to the lower court, the same thing will say that you file either section 37. But how can I file a section 37 application without knowing anything? I don't even know what has
So
been.
what can I do?
I should direct upon the respondent to give.
How can I direct the respondent? They are not even they are not amenable to this jurisdiction.
No, they have filed. They are in the arbitration.
You go
proceeding.
before the arbitrator.
I don't. No, kindly see the.
The petitioner is the
Lordship,
division of
kindly
application
help
is
me.
not maintainable in its present form. The petitioner is granted liberty to approach the whom?
His name is Ashish Bhattacharya. Only this much. No phone number, no address,
No,
nothing.
Ranjit Harijan.
Ranjit Harijan, I have written a letter to him. He did not respond to that.
Approach Ranjit Harijan. The respondent.
No,
in the
Ranjit Harijan is the petitioner, Lordship. He is the petitioner. Ranjit.
Chandan Mondo. Who has initiated the arbitration?
This Chandan Mondal.
Who are they?
He is the person who has alleged that I have signed a money bond agreement.
All right.
Now, Lordship, I have approached him, Lordship. I have written a letter.
All
to him.
right. Approach the Mr. Chandan Mondal, the claimant, in arbitration case number 179 of 2022 for the name and address of the sole arbitrator, Mr. Ashish Bhattacharya. Upon such furnishing of such name will be furnished within a week from the petitioner approaching Mr. Chandan Mondal. Did it? Yes. Next. Not today. Maybe lovely tati dako. 24. Dako the 5. Come. No, it's okay. What is this? Impute?
Order is at the last page. But the suit is for declaration for securing my tenants. And I was.
What are you aggrieved by?
Only a single line, Lordship. There was an interim order on account of deficit court fees. Interim order got vacated. I just want restoration of the.
How can I give that order?
Lordship,
Interim order is gone. That means your interim order is rejected. That is an appealable order.
There is an error in the order that on account of deficit court fees, it was 8 rupees instead of 10 rupees. That's why it will not be rejected. But it is not.
Where is the order impugned?
Last page, order number 14, dated 1st April 2020. So, 1st March 2020.
Order number
14. 14. And on the next day, the hearing of the
first what?
1st March 2023, order number 14. On the next coming day, it had been fixed for hearing of the order 39 rule 1 and 2 application. But the interim order was
Extension was rejected.
Extension was rejected on account of deficit court fees, because I am the advocate.
1 minute, 1 minute. In the said petition, plaintiff has not paid sufficient court fees.
Yes, ma'am. Because I am moving from Kolkata to Baharampur for appearing in this matter. By default, it is admittedly a deficit court fees was there, and it was only 11:30.
Extension not given is also amounts to rejection of a prayer for ad interim order.
No, Lordship.
No, no, yes.
On the next date, the hearing being fixed. On the next date, Lordship, kindly see, on 21/7/2023 for hearing of
1 minute.
And
the moment your interim order is not extended, it amounts to denial of an ad interim order to you. Isn't it?
Yes.
Then is it that an appealable order? The reason may be whatever, but that correctness of the order, who will see?
So then I have misconstrued that I was under this proof.
Order of refusal or grant of ad interim order is an appealable order. Now, whether refusal to extend an ad interim order also amounts to a refusal of an ad interim order. All right, you serve and come. Let's see what your other side. But I think you have to prefer an appeal. It is a good ground, but
May I serve and come back if that
it will be only delaying the process.
Everybody in the courtroom, it is only 11:30. That boy is coming from Kolkata. It is not a manner that it can be rejected. Okay, I will consider thereafter this order came. And nothing is there in the record that I have not extended earlier wise. Every time I extended. And on that day, order 7, rule 11 application being filed and served. And on the next day, my hearing is there for
All right, serve and come. Let's see what your provided your other side is kind. If they are not kind, then you are in trouble. Yes. Service upon the opposite party. Affidavit of service on the next date. The petitioner contends that without allowing the petitioner to put in the deficit court fees on an application praying for extension of ad interim order of injunction, the learned civil judge, Junior Division, 2nd Court, Baharampur, Murshidabad, rejected the application for extension and fixed the suit for hearing of the application under Order 7, Rule 11 of the Code of Civil Procedure. Service bollam. Where are they? Baharampur.
at Baharampur.
How long will you take to serve and come back?
30 days or 21 days.
Service upon the opposite party. Kojon ache?
On 3.
Opposite parties, as also the learned advocate on record for the opposite parties. Conducting the case in the court below. Stay of all further proceedings entitled suit number 380 of 2021. Pending before the learned civil judge, Junior Division, 2nd Court at Baharampur, Murshidabad, up to August 31, 2023. Let this matter appear on July 17, 2023. Under the heading urgent motion. Come back. Convince your other side and come back. Yes.
Lordship, 25 armed petitioner. Not complete.
Service, first let me see whether it will be admitted. Top of the service. You will do it?
No.
Not to what you want, not this week. All right, not this week. Yo, মামলাটা কি দেখি তো? You are who? Who are you in this? Oh, চলে গেছে? ঠিক আছে। Not this week. The other side has come.
No, no. He's in some difficulty. We kindly keep it sometimes
Not
next week.
today,
Next week. Next week.
21 টা not this week করে mark করে রাখো।
Time could be fixed for the matter.
কেন? খুব ভালো মামলা। What is the matter?
Well, he wants an
It
injunction.
will be automatically taken up. Why I'm saying these will automatically come in front. What the new matters will be at the bottom. So I don't need to fix any time. It will be taken up.
Well,
Injunction refused by both courts.
yes, both courts.
You are the petitioner.
No, no.
I'm for the petition. ঠিক আছে। It will be taken up. don't worry.
Well,
Lordship, I appear for the petitioner in this matter, led by Mr. Kochumno Sinha. Lordship, this is an application seeking expeditious disposal of a title suit, Your Lordship, which is pending before the learned civil judge junior division at Paragon since 2013, Your Lordship. I am the defendant before the learned court.
Any applications are pending? Are there
Your
any
Lordship, there are
interlocutory
other
applications?
plaintiff who is the opposite party in this matter. Your Lordship, he has preferred an application for amendment of pleadings after trial has commenced, Your Lordship. And till date
And that application has not been heard.
has not been heard.
Take
of.
down. The petitioner is the defendant in a suit for
Your Lordship, it's a title suit for declaration.
in title suit number 580 of 2013 pending before the learned civil judge within bracket junior division at Barashat. First court at Barashat. The petitioner prays for expeditious disposal of the title suit which is pending since 2013. Next paragraph. It appears from the records that an application for amendment of the plaint has also been filed by the plaintiff which is yet to be disposed of. Considering the fact that the suit is dragging since 2013, you have, how many adjournments have you taken?
Your Lordship, the matter was by an order which was passed on the 17th of February.
What is the stage of the suit?
Your Lordship, the stage of the suit is that the trial has commenced, Your Lordship. Issues have been framed and the plaintiff has
Evidence has started.
affidavit in chief has been given by the plaintiff, Your Lordship.
And the suit is at the stage of evidence. Expeditious disposal, a direction for expeditious disposal of the suit would inure to the benefit of both the plaintiff and the defendants. Hence, prior service of notice is not required for disposal of this revisional application. The learned court below is directed to adjudicate the suit, including all interlocutory applications pending, including applications, if any, which may be pending within a period of 1 year from date of evidence, 1 year from date of communication of this order. This court has not gone into the merits of the application pending, either of the pending application or of the suit. The learned court below shall proceed independently and on the basis of and in accordance with law. A copy of this revisional application be served upon the opposite party along with a server copy of this order. Revisional application is disposed of. Now,
For the petition. The petition is aggrieved by the order passed by the State Commission, dismissing the complaint on the ground of only non-joinder of parties. Your Lordship knows that the partners have been made party in the suit.
this is
in
an
the
appeal
complaint.
order.
No, my lord, the division is also maintainable.
No.
There is the judgment of Honorable Justice Shomposh. I will place that judgment, my lord, which says, my lord, give me one opportunity.
This is discretion. Non-joinder of parties is a finding of fact. Alternative remedy cannot be a bar if there is substantial injustice caused or natural justice has been violated on those
But
grounds.
on that ground, my lord, the entire complaint has been dismissed. Your Lordship kindly see, my lord, then it's a definitely, my lord, injustice caused to the party. Because the partnership firm is not a juristic person called like company. But the partners have been made a party. If your Lordship sees the
All right, let
penalty
me go through the order.
Yes, yes.
No, it's unfair. That is one of the reasons. Then he has found complainant has also not paid the amount as per the payment schedule and of the agreement for sale.
Your Lordship sees the penultimate page. Well, the reasoning. Accordingly.
Whether the construction has been completed or not, or whether the complainant has failed to pay the amount, it is not clear to us, since the complaint has not made the developing
Yes, well,
firm
that
as
is
a
the-
party.
that's why, but partners
Inform
have been
has
made a
failed
party.
to substantiate his case, and as the complaint case fails for non-joinder of necessary party.
Yes. Well, that is the sum and substance. Now partners have been made a party. They are because partnership firm is not a juristic person like company. But if the partners have been made a party, well, they can answer. Although they have not appeared.
Yes, but go and file an appeal. Why
Your
227?
lordship, but if this is a palpable, my lord, injustice in a case, if feed case, your lordship can, my lord.
I can, but they have found that according to
But
the
you will
agreement
see
for
this fine,
sale,
yes.
you have not paid the schedule on the scheduled dates.
My lord, the agreement for sale, I have made the part payment. My lord, there are certain.
But the commission has found on fact that OPs are responsible.
But ultimately, on that, my lord, this has not been dismissed.
Moreover, complainant has failed to pay the amount as per payment schedule of the agreement for sale.
But ultimately, my lord, the ultimate analysis, if your lordship sees, well, the reasoning has been
Whatever
given,
the ultimate,
the non-joiner
just
of
take
parties.
down.
Non-joiner of parties, my lord, on that ground, my lord, complaint should be dismissed. Well, that's why, my lord, I'm beseeching.
Yes, so
Let
file
them
your-
come, my lord. Let them come, my lord. Your lordship, I serve a notice. Let me try my luck. If I can satisfy your lordship on that point.
No, you can't satisfy me because this finding is
Finding, my lord, is a
a matter of fact. How can I get into
No, I
that?
am not on that. My lord. Question is not
And the
whether.
court said this cannot be ascertained because you have not made the developer a
But the
party.
partners, that is why I'm joining issue. My lord, the partners have been made a party. But the partners are quite.
Mr. Kali, it is not about whether you have a good case or a bad case.
Lordship.
I agree with you. But when this is a finding on merit,
Lordship.
that for non-joiner of necessary parties, the complaint should fail also because you have not paid as per the schedule, the complaint should fail. So that is an adjudication on merit. How can I in 227 get into that?
So for non-joiner of parties, my lord, that should not be, my lord. That is coupled with, my lord, that. So, my lord, ultimate.
Yes, so can in 227,
My lord,
when
you
there
know,
is an appellate court,
is the
no,
reasoning, my lord.
then everything we have jurisdiction to do about everything. Then all the procedural
Article
statute has to be given
227,
a
my lord,
go by.
your lordship has got ample power. My your lordship, there are catena of decisions.
Now, those
My lord,
ample power and emboldened
May I bring two decisions, my lord, that to satisfy the.
I have also passed decisions.
Yes, yes.
I have also
In a field
given
case.
here the finding of fact that the complainant has failed to pay the amount as per the payment schedule of the agreement for sale. This itself is a finding on merit.
But ultimately, my lord, the finding hinges
Take
on
down
the subsequent, my lord, the.
whatever it hinges on.
Non-joiner of parties, my lord. That is the main ground. If your lordship sees ultimately, that's why, my lord, the complaint has been dismissed. So, my lord, I will be without any remedy because.
Why you go and file your appeal against this order?
My lord, appeal revision, my lord, more or less, my lord, this is also, my lord, an offshoot of that, my lord. So far, my lord, that I can
Then we
also
can
challenge.
be tribunals only. We don't have free high court.
No, my lord, High Lord, but if I, my lord, I challenge particular this portion, my lord, that the non-joiner of parties, that your lordship can.
If if I correct the non-joiner and add someone to be added, will that finding of merit go away? That you have not paid?
No, I
Take
am
down.
not on that, whether that is necessary or not.
Although the ultimate, the petitioner has challenged an order dated February 10, 2023, passed by the Learned State Consumer Dispute Redressal Commission in complaint case number CC/321/2018. Stop. By the order impugned, the complaint case was dismissed on the ground of non-joinder of parties and also on the ground that disposed of. On the
That is also disposed of means, my lord.
oh, dismissed. Dismissed on contest against the opposite party number 1 and dismissed ex parte against the opposite parties numbers 2 and 3.
They are the partners.
The ground for dismissal was
Hey, my lord, the order is also absolute.
on contest against opposite party number 1 and ex parte against opposite party numbers 2 and 3. The order is a detailed order by which the facts and the arguments advanced by the parties contesting the proceedings have been dealt with by the Learned Commission. The Learned Commission found from the monies received, that the money receipts were issued by the developing firm Messrs. MS Construction, that the opposite party number 1 did not
Landlord.
was not responsible for any latches on the part of the development firm, developer করে দাও। Developer Messrs. MS Construction, on the part of the developer, the complainant was found to have failed to pay the amount as per the schedule of payment in the agreement for sale. The partners of the construction company did not appear before the learned court below. Full stop. In the body of the petition, it has not, or in the cause title of the petition, it was not mentioned that the opposite parties numbers 2 and 3 were the partners. Thus, the commission rejected the complaint. Learned advocate submits that rejection of the complaint amounts to substantial injustice. The complaint should not fail for non-joinder of necessary parties. The partners of the developer, which is a firm, have been made parties. However, as there is a specific finding on merits that the complainant had not paid the amount to the developer as per the payment schedule of the agreement, this court is of the view that the rejection is also on merits, and hence the order being appealable, the petitioner must avail of the remedy in accordance with the statute. The divisional application is thus not entertained and disposed of accordingly. The petitioner is granted liberty to take back the certified copy of the judgment impugned, order impugned, and upon furnishing a copy thereof. Now,
No, I will petition, though I have paid for early disposal of the injunction application. Kindly see the orders complained of.
if you paid for that, you will get that. I
Kindly
cannot
see the
change beyond your
kindly see the orders complaint. Before 5th January 2023, there was an order for hearing of the injunction application. By recording an erroneous order, ad interim order of injunction was vacated. Kindly see the order. No date was fixed on 5th January. That is the conduct of the trial court. Trial court, what is the trial court is?
Have you challenged that order?
I have not challenged that. But subsequently, I was ready for disposal of the injunction application. But kindly see the last order. Trial court allowed the defendant to file an application 13 Rule 7 in the meantime, fixing a date for hearing of the inspection application 13 Rule 7. That has not been filed. But when the petition has not been filed, how the date can be fixed for hearing on that day instead of hearing an injunction application? Kindly see this order.
Where is that order?
The last order. What is going on in the trial court? Defendant has been encouraged by doing something. 13 Rule 7 has not yet been filed, fixing a day for hearing of that application instead of hearing an injunction application, and date will be fixed for hearing of the order 13 Rule 7. But no such application was filed at all by the defendant.
Hearing of order 39 Rule 7 is necessary for the purpose of disposal
Not
of
been
injunction.
filed by the defendant. Kindly see the orders. Directed to be filed in the meantime. Learned trial court fixing a day for hearing of the application local inspection on the next date, but application has not been filed. Directed to be filed in the meantime.
Defendant prayed for leave, that was given.
No application has been filed, Malak.
So,
Cannot be fixed for hearing of that application to delay the hearing of the injunction application.
what is the interest of the judge? Take down. The petitioner is the plaintiff in title suit number 83 of 2020 pending before the learned civil judge, Junior Division, Second Court, Hooghly, Shodor. It appears from the records that the application for, you are the defendant or plaintiff?
I'm plaintiff.
That the application for injunction has been kept pending and liberty has been granted to the defendant to file an application under Order 39, Rule 7 of the Code of Civil Procedure. A date has been fixed for hearing of the said application, which has not yet, according to the learned advocate for the plaintiff, has not yet been filed.
From the order itself also.
Learned advocate, has it been filed now?
No.
Learned advocate submits that in order to delay the hearing of the injunction application, such order has been passed and the defendant is taking advantage of the order. Next, having heard the learned counsel, having perused the records, this court is of the view that the application for injunction should be closed off within a period of 2 months from the next date fixed.
Yes. Yes. Well, within 1 month. Well, I obtained an order of injunction that was wrongly vacated.
Within 2 months from the next date fixed, irrespective of whether an application under Order 39, Rule 7 of the Code of Civil Procedure is order within 2 months from the next date fixed. This court has not expressed any opinion on the merits of the injunction, either on the merits of the injunction application or on the merits of the suit. As this is an innocuous prayer for disposal of the injunction application.
No adjournments. No further adjournments.
Service of notice upon the learned advocate, upon the opposite party is not necessary.
Well, on that, the defendant will not pray for any adjournment.
What is the next date fixed?
On the day of hearing the local inspection applications, only date fixed. No injunction application fixed for hearing, keeping it abeyance.
Yes, a copy shall be served. Serve for the bolun along with a copy. Okay. Serve them on copy. Next. তিনটেটা ডাকো You are? ঠিক আছে 29 টা ডাকো কতক্ষণ ধরে দাঁড়িয়ে আছে ডাকো 29 What is the stage?
My lord, it is for the acceptance of WS, which is barred by the limitation by the opposite party.
So you want what?
My lord, I am just paying for expeditious disposal. There is also one application under Order 6 Rule 17, which is filed by me, is also pending, my lord.
What
And
is
they
the
have
order for? Where is the acceptance of WS? When is the next date?
My lord, the next date is on 19/9/23.
Ex parte hearing then?
My lord, they are coming again and again with a different application. And the matter has been adjourned day by day, my lord. The next date is fixed on 19/9/23.
It is going on ex parte hearing.
Yes, my lord.
WS has not yet been filed.
No, my lord.
Lord, they have appeared on 7/6/2022 and filed wakalatnama on with a application to acceptance of WS that was accepted by the learned court, my lord. On the next date, Your Honor, when the date was fixed for filing of WS, Your Honor, they prayed for time, Your Honor. Sorry, my lord. The learned trial court, my lord, reject that application and fixed for ex parte hearing, my lord.
All right, take
Thereafter,
down. That ex parte order has not been recalled.
no, my lord.
No, my
WS
lord.
has not been accepted.
No. They are barred by limitation, my lord.
The petition is aggrieved by the inordinate delay in disposal of title suit number 727 of 2021 pending before the learned Judge 13 bench City Civil Court at Calcutta. The petitioner prays that the hearing of the suit be expedited and the pending application order 6 rule 17 you have filed.
Yes, my lord.
For application for amendment of the plan be disposed of
And
at an early date.
application filed by them. The two
They have
applications
also
filed by them.
What are the applications?
The first application to
for acceptance of
acceptance of
WS
WS
and the
Alright.
other application for
The pending applications. Pending applications filed by both the parties be disposed of at an expeditiously. Our early hearing of the suit.
kindly fix a date.
It appears from the records that the suit is proceeding ex parte and an application for acceptance of a belated written statement is also pending. Without expressing any opinion, either on the merits of the suit or on the merits of the pending applications, the revisional application is disposed of with a direction upon the learned court below to expedite the disposal of the pending applications. The pending applications shall be taken up in the order serially and disposed of by the learned court below within 2 months from the next date fixed. Thereafter, the suit shall 3 months from the next date fixed, full stop. Thereafter, the suit shall proceed expeditiously. Unnecessary adjournment shall not be given to the parties. Yes. A copy of the revisional application be served upon the opposite party. How many opposite parties are there? This order shall not be construed as an opinion of the court on the merits of the application filed by the defendants in the pending suit. All these applications shall be disposed of on their own merits and in accordance with law. Yes. Yes, call that 3 p.m. matter.
But I'm for the petitioners.
No, this might not take very long.
On the 11th?
Let me Mr. Shobhut Jyoti.
বেশিক্ষণ চলবে না, অল্প ছোট ভাট। But in connection with the section 34 of the Arbitration Conciliation Act, praying for setting aside an arbitral award, we took out an application under section 36 for stay. But the stay was granted subject to condition.
Bank guarantee.
Bank guarantee.
Failed.
No, bank guarantee, my lord, I sought to prepare that within time. My bank, my lord, required that the particulars of their bank is required for preparation of the guarantee. So before the time expired, my lord, we gave them a letter asking for the particulars of their bank. They could not do so. Therefore, my lord, I was prompted to take out an application for extension of time before the court. And my lord, that application was not made before expiry of the time period that was granted by the
Bank
court.
guarantee was to be deposited within
4 weeks. Prior to expiry of 4 weeks, order 27th,
Give me the date.
27th April was the last date.
When was the order passed?
But the order was passed on Lord 28th March. 30 days therefrom, Lord, is 27th.
28 March 1977.
Page
You
77.
ask them for the details when?
Lord, yes. Lord, we asked them for the detail supplementary. Supplementary. So, dear Lordship, kindly Lord, allow me to file a supplementary affidavit.
6th April check.
Yes. No.
Then what happened after that?
But after that, Lord, we made an application before the court
But the learned judge refused to, my lord, they extend the time for, my lord, compliance of, my lord, the order that was passed, my lord, in section 36 application. But your lordship will kindly come to, my lord, the impugned order for once. But the learned judge, my lord, I made the application within time. But I have a right under section 148 of the Civil Procedure Code for seeking extension of time. If I can satisfy before the court that I was not, my lord, in other ways, my lord, trying to defeat the order of the court, the learned judge, my lord, could have. But the net result is, my lord, they are proceeding with, my lord, the execution. But if your lordship kindly comes to, my lord, page 77 first, the first order. But there are two, my lord, parts of this order. One is, my lord, for security concerning, my lord, the awarded amount. And other was, my lord, the occupational charge concerning, my lord, my occupation to the property, which was to be continued, my lord, during the pendency of the section 34.
He got angry because he challenged that award by filing a civil revision.
That was an expeditious hearing.
Anyway, yes.
That was an.
Page 93.
Lord, your lordship may kindly come to page 93 for once.
Oda ki hoy check? What is that check you have given?
No, that is for the 11 lakhs, my lord, that was given, my lord, towards the occupational charges.
Which they returned.
They returned, my lord. The reasoning for the return is that the client should pay this 11 lakhs and not the advocate on record for the client. That was the first reason. But advocate on record. But they are supposed to get the payment. They are not to see the sign the check. The তিনজন তিনটে পাতা বলছি সবাই।
চারজন জুনিয়র সবাই ready, কি করা যাবে?
My lord, other than paying my client, my lord, they are paying only the lawyers. My lord,
I'm now
the unfortunate. Now, my lord, let me place the case. My lord, first point, my lord, two, I'll very short. First point is, I am not saying 227 is not maintainable, but my lord, whether my lord will exercise discretion under 227 at all, particularly this is a commercial matter and the Commercial Court Act, my lord, section 8 bars a revision. Revision doesn't lie. Second, this is an order passed under section 36.
Judgment to the contrary to this proposition.
Section 36 of the Arbitration and Conciliation Act also. This is an order passed under section 36. Under the Arbitration Act also, it is not an appealable order. Appeal, if any, lies in the Supreme Court. This is a small objection, my lord, I raised on the technical objection, if I may say so. Now on merits. Now, my lord, to cut a long story short, my learned friend's client are in occupation of the property since 2017 without making any payment whatsoever till date. What payments not made? Before the arbitrator, there was an interim award of 1.5 to 2 crores. 2 crores plus GST. Interim award not paid. Section 34 filed. There was an order, secure it by bank guarantee, not secured till date. Then comes the final award. Final award, according to us, it is more than 5 lakhs. Be that as it may, my lord, the learned 5 crores. The learned judge has ordered that secure bank guarantee of what has been stated in the award as the principal amount of 3 crores and odd. Passed when? In March, 34 weeks time has been given. Submission was made to your lordship. They asked for my bank account, which I did not furnish. Well, the first question, under which law for furnishing bank guarantee, my bank account is required? Bank will give an undertaking, unconditional guarantee, saying that. So, my lord, this is an excuse, and this they have been doing it before the arbitrator. They said the money is due, but we cannot pay because they are not raising bills on us. And on this basis, the arbitration proceeded for 2 years. And my lord, now all their points have gone. Now kindly see what the learned judge has said. Time was given for 4 weeks. Time has lapsed. Even today, they can't show your lordship the bank guarantee. Firstly, my lord, under which provision of law I am to give my bank account? It is not a direct transfer. Bank guarantee is, my lord, my name will be mentioned that whenever the court directs, I will place it to the bank and my lord, bank will pay directly to me. My name and particulars are there. So, my lord, the entire premise is based on, my lord, a frivolous, my lord, they cook up matters by which they can delay
2 or 3 days before the advocate writes and my lord, they my lord do it. The second submission made was check has been sent in the name of the lawyer. This lawyer, my lord, we are very apprehensive because before the arbitrator,
The check was signed by the lawyer.
yes, signed by the
Page
lawyer.
94, page 94.
Because my lord,
But
we are,
addressed to them.
yes,
Page 7.
we are apprehensive because before
No, page 94 of the main revision application.
we are apprehensive because my lord, before the arbitrator, my lord, a third party had made payment and the third party, my lord, they put it up as a defense. So we don't want any payment from the third party. Direction is they should pay us. My lord, at the end of, my lord, this is so far as the bank guarantee is concerned. Second part, my lord, the award is, my lord, twofold. There is a monetary award. My lord, why? Because, my lord, under the agreement, they were to pay, my lord, the agreement was for, my lord, operating a warehouse. Lordship knows all these, my lord, Amazon and all these companies, my lord. Now warehouse business is, my lord, logistic hub. My lord, it's a more fancy name, but it is, my lord, a composite of all these.
All the stuff is packed.
Yes, packed, stored, and my lord, trucks come in, go out, and all this stuff. Now, my lord, I am the owner of the land. I had set it up. They are only to operate. In terms of the agreement, they were to disclose what is their turnover. Agreement provided I get a percentage of that turnover. In the alternative, a minimum guaranteed amount was there. Well, they don't disclose the agreement, neither before me nor before the arbitrator. Be that as it may, on the
Execution is proceeding now, right?
Yes.
execution is proceeding tomorrow. Last chance. The judge has said over there, last chance tomorrow. I will pass an order of eviction if you can't show stay. But cut a long story short, from 2017, we are in 2023. Kindly visualize my predicament. 23 acres of land in Asansol. 23 acres of land. Not a single penny I have received, and I am internal lessee of Asansol Development Authority with a right to sublease. My lord, not a single penny paid, and every time, my lord, we put it in execution, one objection on one pretext or the other. And there is no stay of the interim award. The stay was, my lord, lordship knows, under section 36, the order 41, rule 5 principles have been borrowed in. That is also, my lord, discretionary. So, my lord, the learned judge has exercised his discretion in not granting any further time.
When can you give the bank guarantee?
But as soon as, Lord, to answer my learned friend.
This 11 lakhs is also directed by.
My lord, 11 lakhs, I'll tell you,
Lord,
lordship.
Lord,
11 lakhs, my lord, 11 lakhs is, my lord, following the Atmaram principle. Since there is a order of, there also, my lord, I'll tell you, lordship, what they have done. My lord, the award is of 17 November 2022. So from November 2022, if, my lord, Atmaram principles are followed, then, my lord, 11 lakhs is to be paid for November, December, right, 8 months. So, my lord,
Per month, it was
11 lakhs per month. So, my lord, today 8 months is another 88 lakhs. My lord, they construe the order of the executing court as only from the date of passing of the order. And
order was passed on.
order was passed in March, 28th March.
The Lordship may see page 87, the ordering portion. I am following the ordering portion.
So I am saying, my lord,
Learned friends, but imagination of an order will not do.
I don't say they'll have to imagine. Kindly see the order. So, well, this is what is being done. So
85.
87, ordering portion.
In the section.
But that is in section 36. The order starts from page 77, but the operative portion 87.
My lord, order is saying, kindly see, my lord, para 10, last 4 lines. An order of eviction has been.
All right. So this is March. So even if we take it, what you have your thing, that will be subject to final decision of the.
No, 11 lakhs per month within 7th of each succeeding month. And, my lord, as per Atmaram principle, it is from the date of the award. Either of our imagination is correct. Either my learned friend's imagination is correct.
For
or my
succeeding month.
They
Succeeding
can't-
month.
So, my
All right. So this was February.
this is March. Order date is
March succeeding month I am to pay.
March, April, May, June.
Yes.
You pay 44 lakhs.
Very well, I will do so.
And you pay. give
Secondly,
the
your
bank
lordship kindly
guarantee,
sees.
And you pay cost of 1 lakh.
But your lordship will kindly see, my lord, when I have sent, my lord, the check through the client, They again
why will
refused.
lawyer sign
No,
the
not the lawyer. This is the second instance.
My lord,
when I sent
kindly,
it to the
kindly do not
client.
dispose of the matter, my lord. Kindly keep it tomorrow. Let them come with the money before your lordship. My lord, I can assure your lordship something else will happen. Tomorrow's hearing will be scuttled. My lord, lordship is
Acha, do one thing.
But this is not the
my lord,
check
let
that
them
was
come
sent.
with
They have
the
to-
money and bank guarantee tomorrow before your lordship. Lordship
This
will
is the
pass on.
client's check. It is not the
My lord,
lawyer's.
no check, my lord. Demand draft. Let them come and bring it.
Why no check?
They had sent it back, my lord.
I will put them to condition.
Very well.
Tomorrow the court can only decide.
Very
that
well, very
part.
well, my lord. Will
I'll-
do that.
Yes, now. এটা ফেরত দিয়ে দাও না।
এটাই দিয়ে দেবো,
Bank
22 লাখ টাকা শোনো।
না, না,
এটা 33
My lord, kindly ensure that the bank guarantee.
কবে থেকে মার্চ থেকে
My lord, what happens, my lord, what happens, my lord, from August to, my lord,
No, why should I see? No.
August to March, my lord.
But I'm handing over, my lord, the check. These are valid checks as of now.
You hand it over,
I'll-
but
but-
your client is here.
This will be
Representative
33
is here.
lakhs. This 33 lakhs here. But
Further
today, here and now, my lord, I'm entitled to an order of injunction.
May, 33 will be till May, June, you will pay tomorrow.
Yes, and whatever that is, my lord, in the balance, I will clear it off.
Bank guarantee, let it be produced today or tomorrow.
But bank, so far, my lord, I'll now address your lordship on the point of bank guarantee, which my learned friend said that, my lord, that where's the law to that effect? But there's no law to that effect, but the bank required at page 8 of the supplementary. I made an application for the bank guarantee within the time.
My lord, we
But the
have
bank
enquired-
gave me a letter.
The
My lord,
details.
kindly have a look.
Kindly have a look at, my lord, this page 8. my lord.
Kindly have a look at page 8. We inquired for the bank. Bank have said they have forced me to write this letter. I have clarified it. Kindly
This
look at
comes
page
from
8.
Mr. Chaudhary, my lord.
This letter,
We don't find anything, my lord, anything on record.
this letter is issued on the specific demand of the
If your
customer.
client has 3 crores in the bank, definitely the bank guarantee can be given today itself.
But the bank guarantee, my lord, requires some time, my lord, to be drawn up.
What were you doing?
No, my lord, unless your lot, I do have the money, my lord, I'm doing the business. I'm paying here and now 33 lakhs.
I don't want 33 lakhs. I want the bank guarantee.
But he will
Yeah,
certainly
my
get
dues
the
are
bank
8
guarantee. If he doesn't get the bank guarantee, he's free to, my lord, execute and
That
get.
is what
policy.
I'm doing.
But then you will come again.
That
with
is what I am
But
doing.
that is the reason I say, my lord, as a stopgap measure, let them be satisfied with 33 lakhs, which they can
No, my lord,
appropriate as of today.
Tomorrow, let them pay 33 lakhs tomorrow also. I
That's-
don't need
You
it
give,
today.
where is your representative? Let them take it now. Let me put
Yeah.
it.
Yes.
Where is he?
Mr. Bose has refused, my lord, with a covering letter this check.
Bose can accept.
There may be a difficulty. The person who is here, he is no longer connected with that. So technical difficulty, my advocate on record will take.
Yes, take it.
Well, yeah, because he has, my lord, who has given it back.
The checks. Bearing numbers dash.
But yes, we'll give the number, but these are the demand draft. But these are demand.
The demand drafts bearing numbers dash 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 drawn on dash bank.
নাম্বার লিখে নিচ্ছি
একটা কেন তুই
দাদা এক এক করে
করতে হবে। 3 শুনতে সময় লাগছে। এটা কি ডিমান্ড অ্যাকাউন্ট পেই চেক তো।
এই
এই
একটা
কি-
না,
কি দিয়ে-
প্রথমটা অ্যাকাউন্ট পে বাকি দুটো ডিমান্ড
প্রথমটা-
অ্যাডভোকেট চেক ছিল যেটা
But advocates check, kindly do not ask me to take my learned friend will be in difficulty.
Anubha Prakash, deputy manager,
এটা কি কি আছে ভাই?
Ritima Dupe, senior manager.
Well, that is a demand draft. That appears to be a demand. draft.
অ্যাকাউন্ট পেই কেন লিখেছে তাহলে?
চেক তো
You know, bank draft is the like
আচ্ছা, the demand drafts.
banker's check.
Okay, yeah.
কোন তুই
Drafts, amount number, oh, আচ্ছা, DD number দেয়া আছে, 7406, 7346, and 0298, just check it. এগুলো একটু দাও তো, ওই ওদেরকে। Have been produced before the court and handed over to the learned advocate on record for the opposite party.
082958.
082958. 082958.
ভ্যালিড আছে কিনা দেখে না
958.
3 months
Over
3
to the
months
advocate on record,
3 months
learned advocate on record for the
3 months না তাহলে একবার যখন
opposite parties.
সায়ন্ত
Opposite party number 1. Mr. Bose, learned advocate, has taken delivery of those demand drafts. Full stop. the further demand draft for an amount of rupees 11 lakhs for the towards occupation charges for the month of June 2023 shall be handed over to Mr. Bose within the course of কালকে ডেটটা দিয়ে দাও
আরেকটা তো
কালকে মামলা আছে
জুনেরটা দেওয়া আছে এপ্রিল মে জুন ও তিনটে দেওয়া আছে মার্চের অর্ডার হয়েছে
মার্চেরটা succeeding month. Succeeding month.
March vanishes, August to February vanishes.
7th of every month I'm supposed to pay.
Lord, from the date of the order, your lordship will find the order date is not 28th of March.
every month.
Yes, so the first payable date is not 7th of April.
That is not the
April, May, June.
তিনটে মাস what
No,
happens
it is,
from August to February? No.
But we are not going, Lord.
August is the award. Sorry, November.
That will be decided by the law.
No, that has not been directed.
That
What my
will-
learned friend is asking for, he has not challenged this order.
তাহলে আর কালকে আর
Once he
11
comes,
লাখ
I'll take
দেবে।
the point of 227
Cost
maintenance.
of rupees 1 lakh shall be paid to the opposite party number 1 within the course of কালকের date. ওই 11 লাখটা বাদ দিয়ে দাও।
1 লাখ টাকা তুই দিয়ে দিবি
With regard to the occupation charges from the date of the award, the opposite party number 1 will be at liberty to approach the learned court, executing court for necessary clarification and or orders.
don't give that debate.
If such clarification is sought for, the same shall be disposed of
Take it to the third.
in accordance with law upon contested hearing.
Very
Now, with regard to the bank guarantee, the learned, further time of 48 hours is given
But 48 hours,
petitioner
Lord.
to deposit the same in the learned court below.
Do you take
না
over?
by Monday, by Monday. আর কান মে by Monday. By Monday.
আচ্ছা,
না না না
Monday 19
তো যাচ্ছে Monday night. ঠিক আছে
এই Monday না পরের Monday?
পরের Monday আজকে তো
পরের Monday, cost বাড়বে তাহলে
না 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 দরকার নেই 19 তারিখ
by 19. By 19. The learned court below is requested to post the matter on 20th June 2023 in order to ascertain compliance of the order of this court.
এই comply করে তাহলে
Although the matter has been posted tomorrow, total compliance of this order may not be possible, and hence such request is being made by the court. If the learned court below finds, who is the judge?
executing court মানে
Lord, that is Asansol
Learned judge,
commercial court.
commercial court at Alipur,
Asansol.
at Asansol.
Yes.
Acha.
Asansol is the executing court, Alipur was the
34 court.
Property is in Asansol.
Shall
No, no.
proceed with the suit, with the execution proceeding being, what is the miss case?
No, arbitration execution
No,
case number
arbitration.
Arbitration
Page 23.
execution case number
3 of 2020.
3 of 2023.
Page
3 of
23, Lord, your lordship.
2023. Expeditiously, if the order of this court is not complied with.
আর যদি comply করিস তখন আমরা
But in the event of compliance,
In
Lord,
the event of compliance, the execution proceedings shall remain stayed. Any default in payment of the occupation charges shall also amount to vacation of the interim order that is passed by this court without further reference to any court.
lordship, a great friend.
DD number gulo, can one of your juniors please write the DD numbers? Just verify them.
Great friend. This was.
Yes. 13 fixed 30 তারপরে তাকো 29 বাজে তো এই দিলীপকে বলো তো আমার সাথে একটু বাইরে দেখা করতে এক্সপেডিশনস গুলো কি করলো 30 is not there. What is yours?
Next.
দেখো 31 একটা হারিয়েছি আর একটা দেখি কিছু করে তার তো নেই কেউ তুমি 31টা ডাকো না বারে
But here, my lord, the question is with regard to the interim custody of a minor. My lord, the father is the petitioner, the maternal.
given to you.
No, what happened, my lord? My application under section 12 has been rejected, my lord, on the ground that the judges raised the finger towards the child. Child said, I am not willing to go. That's why, my lord, it has been registered
this
without
an
filing
appealable
objection. No, it is not an appealable order. It's a revisable order, my lord.
Sure.
Yes, well, I will also check, but you'll have to kindly see. The order, impugned order is 6 March 2023.
Act 8 case na
Act 8 case. It's an interim custody. I am not asking for the final custody. It's a interim custody of the child. Well, the maternal grandfather has been preferred to the exclusion of the father. Your lordship knows that the father after the mother, father is the natural guardian.
the petitioner who is the mother is not there.
No, mother has bereaved her last, my lord, 14 May 2023, my lord, 22. But maternal grandparents been given the child.
How old is the child?
Well, the child is about 5 years old, my lord, 4 years old. Father is there, and also, my lord, the grandparents are also there, my lord. They can also take care, and that is not the, my lord, the question. Question is there are other considerations are there. Whether their father is the natural guardian after mother, my lord. How could the grandparents can be given preference over the father? And there is no objection.
He is for you comfortable with his
Well,
grandparents.
that who will adjudicate? Well, there is no objection even filed on the
Can
first
the
day.
court also adjudicate, tell me, on the
Well,
first
the test, my lord, there are certain parameters. But on the first day, when if the child says they are under the custody of the grandparents, whatever they will taught, he will say that. Well, by raising finger,
cannot take away a 4
no,
year
no,
old
but
child.
because father, my lord, your lordship will be father. There has to be exceptional case has to be made out. Why will not give the father? Because after mother,
Interim custody,
interim custody, but interim custody, mother, kindly see, mother, what basis the judges come to a conclusion. Even there is no objection to that effect on record. I can understand, mother, there is an objection filed by the grandparents because that objection has been considered. Why the father will not be preferred? But there is nothing there. I will serve, my lord. I will serve. I am not asking for my lord, the blanket order. Let them come.
Give you interim custody.
But let me time. It is the father, and my lord, the visitation right also not properly given. It is given, but they are not by not complying. But they are not.
That is different.
That is
For
that
you have to
I
come
will.
to execute.
But my lord, let them come. But because, my lord, the welfare of the child is the paramount consideration. My lord, that has to be there. Because father is quite capable. The grandparents are not only they are old in age, and also whether they are in a position to, my lord, the look after the welfare of the child. Well, that is the question has to be decided. It is at the end of the paramount consideration would be the welfare of the child. Well,
That is why when the child was asked, the
yes.
court found that
Well,
the
child, my lord, your lordship knows they have got no evidential value because he has not attended 7.
then who will decide?
But
Because the father is saying that will be sacrosanct.
but father, my lord,
The emotion of the child is not
no,
equal to this.
emotion means, my lord, father can be excluded provided by
At least to ascertain which set of people a child is comfortable. That is not very
my lord,
difficult.
on
for
the
anyone
first
to
day, my lord, on the first day, I moved an application on the first day, my lord, it was rejected. I can
I will
understand.
not give you interim custody. I might modify.
Well, let them come, my lord. Let them file objection.
Service
They have
upon
not.
the
Well,
opposite
kindly set
party.
aside the order. Let them file an objection. What?
Set aside absence.
No, let them come, my lord. Because there is no objection on record. Why I am not, my lord? Being the father, I will be deprived.
That is why this is an interim order. All right, service upon the opposite party, affidavit of service to be filed on the next day. Let this matter appear in the list on. When do you want it?
My lord, after 1 week, my lord, in the meantime, let me serve.
27 June
20. In the meantime, I will cause service.
at 4 p.m.
Lordship. Your lordship will apply the test, my lord, and I will also bring some decisions.
The test,
But test is the paramount consideration of
the
the
child.
child.
Now,
That your lordship has to see whether, my lord, because father, my lord, this is an exception. You are not giving the custody to father. There must be some
One
clearing
minute.
facts.
father may be the natural guardian and may be entitled. But whether the father is capable of
That's why I'm
raising a 4-year-old child is also an important thing. Can a 4-year-old child be exclusively brought up by a male member without any female intervention? Like a grandmother, maternal grandmother is an issue.
But paternal
Can the
grandmother is
court-
also there. Paternal grandmother is also there.
Why was the child with the maternal grandparents?
Because
all
what
this
has
while?
happened, my lord, when the mother died, but he was forcibly taken custody, and the police complaint is also there.
If this kind of acrimonious relationship is there, then what? All right, let them come.
But that's why I say child should not suffer, my lord. That is my main concern.
Yes, what were you mentioning?
Item number 33 is there another matter?
What you said, Bailiff is going to give?
That is item number 85 minute.
Is there any caveat?
And there is no caveat.
85 to be mentioned Friday te diye do.
Lordship, the urgency is that the bailiff is going to proceed against the property on Saturday itself. Your
So I
Lordship,
have said to give it on Friday.
allow me, Your Lordship. I need to, assuming Your Lordship passes an order directing expeditious disposal, I have to take an order and present it before the.
Madam, what has happened, my lord? There's an appeal pending before the appeal court, my lord. There's a Section 5 application which has been pending for the last 6 months, my lord. Unless the Section 5 gets allowed, my lord, the stay application cannot be even heard out, my lord. We were asking only for expeditious disposal of the Section 5 application. Unless that is heard out
Where? That 85?
in the before the district judge, my lord.
Expeditious disposal.
Of
What do you want?
but otherwise, my lord, I can't say that allow the Section 5 and give the stay, probably with the deepest of respect, my lord.
You can pray for a stay in the learned court below.
That we have already done. The Section 5 hasn't kept pending for 6 months.
In the executing court, you can say that the appeal is pending, kindly stay the
That has been done, but that prayer has been turned down, and
bailiff writ has been issued to the bailiff.
I'm instructed that it has been done.
So when is the matter fixed in the court below?
Last week was last Saturday. District judge not sitting since he's under order of transfer.
Last Saturday was the last date, since the honorable district judge is under an order of transfer. The next date has not been given.
Which place is this?
Alipur court, my lord.
Go for an adjournment over there. What is the last order passed?
In both side file Hazira fixed 9/6/2003 23 for further hearing, and
So where is the bailiff's order? Bailiff position? Further hearing of what?
Further hearing of the Section 5 application, and this has been going on from January till June.
So that I will take it up. The expeditious disposal e diye dilei hobe. All right.
And my lord, in the item number 33, my lord, if it can be taken up, my lord, that is the
338.
and
Tomorrow I'll take it up.
if it can be, some precedence can be given tomorrow.
Tomorrow it automatically, because these are all the matters are for 5 or 6 matters, it will be there. After 5 or 6 matters.
Deeply.